How does that happen? A lot of work. A lot of money, man. When that first started happening, I thought it was just a legacy. You know, because I want. Yeah. See.
Yeah, that's fine. They're going to be in there. Thank you.
Gibson.
Down, they'll start right now, 9 or close to 9.
Really?
Yeah.
Well, tell them the jury's gonna be in the jury box. Definitely, but you don't definitely want to check to see if the jury's up there.
And if they're all here, just bring them out, please.
So if we have to sit here and listen to Sanders this morning on sentencing, do we get MCLE credit? Huh? Couple hours? Gibson? Gibson?
Okay.
Listen, what?
Mhm.
All right.
All right.
Your Honor, the defendant was outside, but his attorney's not here yet, so he's waiting.
Oh, tell them to come inside. Thank you. All right, everyone, I am going to call the docket. If you're here, you need to let me know you are here. If you don't answer the docket, I'm going to assume that you're not here, in which case a warrant may be issued for your arrest. In custody, we have Dane Cortez, Santon Wilson.
Right here.
Thank you. Jaden Green, Tyrell Shirley, Alberto Trevino, Mario Guerra,
Here.
Jonathan Boyd. Jonathan Boyd. That's no relation. All right, we have in custody Christopher Garza, Aaron Trevino, Deshandra McAfee. Deshandra McAfee. D'Angelo Robinson. D'Angelo Robinson. Jesse Salinas. Aaron Sturm.
Present.
Darren Doze.
Present, Your Honor.
Isaiah Gibson.
I'm here on him. I didn't see him this morning.
All right, thank you. In custody, we have Edris Durant. John Garza. John Garza. In custody, we have Maple Hughes. Matthew Salazar. Matthew Salazar. David Rodriguez. In custody, we have Roland Garza. Stephen Smith. Stephen Smith. Davian Graham is in custody. Robert McNeil. In custody, we have Jonathan Tate, Xavier Rodriguez, Valerie Garza, Donnell Ward. Robert Cuellar Lopez. Amber Milligan. Amber Milligan. Justin Schermerhorn. Christopher Gibbons. Either close the door or come in. Matthew Salazar. Janelle Bailey. In custody, we have Justin Perry. Valentine Schaefer.
Present with counsel.
Valentine Schaefer.
Here.
Valerie Castillo. Valerie Castillo. Inger Sawyer is in custody. Jorge. Yes, okay, they just combined it with Taurus too. All right, thank you. Alejandra Almanza, thank you. In custody is Justin Gonzalez, Edris Durant, Jennifer Hernandez,
Good job.
Antonio Rios, Michael Teo.
Council President.
Is there anyone who came in later? Your name was not called. What is your name? All right, you're late. You were late. You need to be on the front row. Your last name is Boyd. Boyds are not late.
Apologize.
Are you just apologizing to me or are you apologizing to the whole Boyd family tree?
I guess everyone.
Okay. All right, yes. What's your name?
Christopher Trinidad.
All right, just give us a moment. Deputy Laura, can you see if all the jurors are here? And everyone, when I say 9 a.m., I mean 9 a.m. All right, to the interpreter, you want to see if the equipment is working?
Mr. Parada is not here now.
You want my cell number in case he shows up?
Mr. Parada, you need to come in.
Just want to get his family on.
Okay. Yes. Michael Salinas. All right, just have a seat. We're gonna get to you.
862-1105. Your Honor, may I be excused? He didn't show up and I gave him my cell number.
But you're gonna have to come back because I'm gonna call it on the docket and we'll see if we need to issue a warrant or not.
What time are you gonna call that?
Well, each side is gonna have 10 minutes for closing arguments, so it should be fairly quickly. Thank you.
If I stay, I can get MCLE credits, right?
Yes. All right, you ready? All right, Brennan, you ready?
I'm ready.
Court is calling. Everyone needs to be quiet and everyone needs to get out of the jury box. Court is calling 2021 CR 7575, State of Texas versus Jose Parada. Can I have parties announced for the record for the state,
Marcus Sanders and Ryan Groomer.
for the defense?
Guillermo Lara and Matthew Allen, Your Honor, for Mr. Parada, and we're ready to proceed.
All right, and we have an interpreter here. If the interpreter, if you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
And if you could state your name for the record.
Maria Rivas.
All right, thank you. Everyone have a seat. Each side, you're gonna have 10 minutes.
Judge, before we bring in the jury, did we remove the page regarding the defendant testifying?
Yes, that's been done.
And then the only other question is the page right before that, as far as any evidence that defendant may have committed another offense or offense or misconduct. I just wanted to make, I guess, defense aware of that and see if they were fine with keeping that page in.
Can I have a stapler remover?
There's no problem with that, Judge.
Oh, you want to leave it in?
I mean, whatever the court wants to do.
No, it's not whatever the court wants to do. Do you want to leave it in or do you want it removed?
You can remove it, Judge.
All right. There's a stapler remover right in one of those things.
Judge, is there an extra copy? Two extra copies.
I thought I already gave an extra. Yes, I'm sorry.
Yeah, we didn't get that.
Just add one extra. Okay.
Thank you.
All right, thank you. So before the jury comes in, are there any objections to the punishment charge? State?
Judge, just the part that we just talked about taking out, the one about whether he testifies or not.
Yes, that has been
That's
removed.
already, but no objections other than that, Judge.
Defense, any objections?
No, just what we stated earlier.
All right. All right. You can bring the jury in.
All right, the jury.
All right, everyone, please be seated. All right, state with regards to the punishment phase of the trial, do you rest and close?
Yes, Your Honor.
Defense, do you rest and close?
Yes.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear as it relates to the punishment phase of this trial. What I'm going to read to you now is what is called the charge of court on punishment. Then both sides will have a chance to give their final arguments to you. Of course, this charge will be taken back with you to the jury room. Charge of the court on punishment. Members of the jury, by your verdict returned in this case, you have found the defendant, Jose PARADA, guilty of the offense of manslaughter. It is necessary that the jury assess the punishment for this offense. You are instructed that the punishment for manslaughter is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. Therefore, you will assess the punishment of the defendant at any term of not more than 20 years or less than 2 years. In addition to imprisonment, an individual found guilty of the offense of manslaughter may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. The defendant in this case has applied on written sworn motion for community supervision, stating, among other things, that he has never been convicted of a felony in this state or any other state. Our statute provides that where a defendant is found guilty of manslaughter and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this state or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If community supervision is granted, the terms of community supervision will be set by the court. If the jury does recommend community supervision, it will be granted by the court. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law would depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict, if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bear County, Texas. Suitable forms are attached. State, are you ready to proceed?
Yes, Your Honor, and we will reserve our time for rebuttal.
All right, defense.
Thank you, Judge. You know, I was thinking about this case as I was coming to court today, and we've all heard the facts, we've all heard the circumstances. And the one thing that you do not have to worry about is that Mr. Jose Parada is going to be a threat to our community. He's not going to be a threat to our community because we understand and we've seen the circumstances of what took place. Right? And thinking about it, we're judging a man on the worst day of his life. And I understand that. I understand there was a loss of life, and I understand that. But Mr. Parada, he's a hard worker. His family came up here and testified, and they told you exactly the same. He's not the type of person that's going to come out, commit crimes, because that's not who he is. That's not what his personality is. And I know each and every one of you struggled with making the decision on the guilt and innocence phase, because this man is a good person. He's a good person, and we've seen him. Now, why am I saying this? I'm saying this because I know this man. He's been to my house multiple times because he's a good friend of mine. He's a good friend of mine, and I know that this man is not only a good person, he's gonna do well because that's the type of person he is. He keeps on fighting. What did his daughter say? He keeps on fighting and he keeps on fighting. He may be down on his luck, but he will not stop because that's the type of person he is. And giving him an opportunity is not saying we don't value the life of another individual. We're saying, look, we've punished him, right? We've punished him and we said, you know what? We think that he's guilty of this offense, but we also think that he is a man that's worth giving an opportunity to. Why? Because again, this is a once in a lifetime situation that nobody wanted to be in. Nobody wanted to be in the situation. Again, by you giving him an opportunity, by you giving him probation, you're not saying, again, I don't value life. You're saying, look, this man has done what he needed to do in his life to be there for his family, to provide for his family. He's that type of selfless person. And we ask for you to just consider the man, Mr. Jose Parada, that sits here before you today. You see how much it's affected him. Throughout the entire trial, he's been crying. Why? Not because of a show to you, but because it still affects him to this very day. And that's the type of person, that deserves an opportunity. Someone who feels that. Someone who knows, look, the situation was not a good situation. You've seen it. And like I said, many of you probably struggled with that decision to say he's guilty. And this is your opportunity to say, look, sir, we understand that we have found you guilty, sir, but we know, sir, that you are going to continue to be a good role model for your family. You're going to continue to provide for your family. And we know that. We know that you're not a menace to our community. We know that letting you have probation is not going to hurt our community because we know the type of person he is. He's a hard worker. He provides for his family. And Mr. Parada has clearly told the family, what did he tell the family? I'm sorry, right? Because he is sorry for the situation that has taken place. Now, in jury selection, we talked about everybody would consider the full range of punishment. Why do we do that? Because you have to consider that the law as it stands allows for a 2-year minimum up to 20 years, right? There are certain circumstances that you would say, well, this individual deserves a prison sentence. If we're talking about gangbangers, we're talking about people who have an extensive criminal history, I get it. I get why you would want to give somebody a prison sentence. But we're talking about an individual who does not have a criminal history, right? We're talking about an individual who is not a menace to our community. I get it if he was someone who we would fear, right? Someone who we would be concerned with if we're out there and we're going to our car, right? And we're thinking, oh no, is he behind me? No, that's not the type of person. You don't have to fear Mr. Parada because he is a good person. And you start thinking about the laws. Why do they give us these laws? Why do they say you can give him probation for this type of offense? because there are situations that merit it, right? There are situations that deserve for an individual to be given probation. And this is exactly the type of situation where someone deserves probation. Why? Because we all know, and we've all heard from the beginning to the end, the type of person Mr. Parada is. He's not the type of person that looks for trouble. He's not the type of person that's going to be looking for trouble. He's going to carry the stigma of being a convicted felon from this moment forward. For the rest of his life, he's going to carry that. He's carried it since the day of the incident. He's carried that with him, and his daughter told you that it's not the same man. It's not my father, because it hurts him. If he didn't care, if he didn't have any regard for a human life, do you think he'd be that sad? Do you think he'd be that emotional? He cares about not only himself, but about everybody else around him. When we asked him, how does this affect you? He didn't talk about himself. He talked about everybody else, because that's the type of person he is. He's a caring person. He's a loving person, and he's a human being. And I want you to think about that when you're thinking about, what am I going to do? How am I going to assess punishment? Because if this man had no remorse, if this man had actually no feelings for the loss of life, I'd give it. But the judge is giving you instructions. He is entitled for you to consider the full range, 2 to 20, but this case doesn't even get close to that. This is a probation case. This is a case where Mr. Parada is going to come back out to the community. He's going to continue to work hard. You're not going to have to worry about him, because he is going to comply. What did he say? I've never failed in what the court has asked me to do. Why? Because he's a responsible individual. He works hard for everything he has, and he's always been that way. And we ask for you to look at Mr. Parada and just look at yourself, right? Just look at yourself. And if someone would pass judgment on you in the worst day of your life, he's lived this nightmare. He continues to live this nightmare. And we just ask for you to please consider giving him probation on this case, because that's the type of case that this is. Now, I don't know what the state's going to come up here and ask you to do. They may ask you to judge based on your own opinions, but this is not a case where this man deserves to be sent to prison. This man does not deserve to be sent to prison. You see the remorse, you see the sadness, you see that because you know that he does not pose a threat to us and any of us. Message has been sent, right? We sent the message. We've made the decision to convict this man. But I will tell you with 100% certainty that this is a good man. I'm just asking you for the opportunity. Please consider, again, giving him 5 years probation on this case. Again, there's a full range, but we ask for you to give him probation, ladies and gentlemen. Thank you. And thank you for your time.
State.
Thank you, Judge. Michael Cepeda didn't deserve to die that day. I think we all agree on that. I started off this trial. I told y'all that Michael had flaws. During the trial, you heard that Michael had a problem with drugs. But yesterday, Ashley Cepeda came up to you and she talked to you about the guy that Michael was before the drugs, for the hold of him. She told you how he was funny, how he was reserved, how he was shy and soft-spoken. And she told you that he was protective. That was the Michael that they were hoping for, that they would see after drugs. But Jose Prada took that from them. Now, so I don't want y'all to think that just because we didn't parade a long line of people and family members up here, that there aren't dozens, hundreds of people who cared about Michael Cepeda, who would get up here and tell you about all the great things about him. That was a choice that we made. The judge instructed you and the charge instructs you that the range is 2 to 20 years. I'm not going to specify a certain number. I think that's for you all to decide. I just want to talk to you about a few things that went through my mind through this trial and through the different witnesses' testimonies. So we heard from, and I'm not saying that Jose Prada is a horrible guy. I think he made a horrible decision on that day. Just like we have people who make horrible decisions when they choose to get intoxicated they drive on the highways, and they kill someone. That's a manslaughter also. And when someone makes a horrible decision like that and it takes someone's life, I think that they need to be held accountable. And I think that prison is where they should go. So we heard from Jose Prada about the financial burden that it was on him. He testified during trial about the $100, and I sort of asked him about that. And I feel like that was pretty disingenuous because we later learned that he's actually supporting all of his family members. I don't like the impression that he left in front of y'all that he was struggling. He could have come out just straight and say, I don't like these. It really doesn't matter how much money he makes, but he wanted y'all to think how devastating this was and sort of justifying his actions. And I didn't think that that was right. He wouldn't admit that he made bad choices on that day. He wouldn't admit that he had other options. We heard also that he was sorry about what happened. He said he was sorry for the family, but not once did he say he was sorry for taking Michael Cepeda's life. We never heard that one. We also heard him slinging mud, somehow trying to, at Michael even after death, when he talked about the shooting that happened. And when I asked him questions about it, it didn't make sense, a yellow car. And I kept asking, how is this related to Michael? And he couldn't explain it to me. He's still trying to cast mud on Michael, even after his death. So in the charge that you're going to get, it asks you to assess a number of years. And like I said, I'm not going to recommend a number. And it says whether you want to assess a fine. I'm saying no fine. The fine doesn't matter. The next part talks about whether you're going to recommend probation. I'm asking that you deny his application for probation. Well, they probably made multiple decisions on that day. The reason that we're all here today, the reason that Michael Cepeda isn't here today is because of Jose Prada. He chose to pull the trigger. He chose to go to that gas station to pull Michael out, to follow him with a gun and pull the trigger and cause his death. That was a choice that he made. And on the opposite end of that choice was a man with a family that for every minute that Jose Prada has to serve in jail is a year for them. It's been almost 2 years to this day that they lost their brother, their son, their father, uncle, grandson. And for every year that Jose Prada has to serve, I want you to remember that it's nothing compared to the lifetime that Jose Prada sentenced Michael to on it. And so that's why I'm asking you to deny his application and send him to prison. Thank you.
All right, ladies and gentlemen, you now have the court's permission to deliberate. If Mr. Kroger, if you could remain behind, please. Everyone, please rise for the jurors. All right, Mr. Seeloff, did your client appear?
I don't believe he is, Your Honor.
All right, and what is your client's name?
Isaiah Gibson.
Isaiah Gibson. Let's see the file on Isaiah Gibson, please.
She put me in jail and said, no.
All right, and can I see someone from the state, please? Brenda, are you ready?
Yeah.
Court is calling 2022 CR 1156, State of Texas versus Isaiah Caleb Gibson. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
James Seeloff, appointed for the defendants.
All right, and Mr. Gibson is not present. Could someone look and see if Mr. Gibson is in custody, please? On the system? All right, and state, we were here last time on August 23rd for you to speak with the complainant. Have you done that?
So we have reached out to the complainant in the indicted case and the witness in the indicted case. The issue with the unindicted cases is that there are about 6 or 7 witnesses where we don't have all their contact information. It looks like it's still being under investigation.
And what are those other cases? What are the charges?
It's the fraud use of credit or debit card. It's 50 plus. It's like a bunch of IDs, but we don't have any phone numbers associated with those names.
All right, just 1 second. Is he in custody? All right. This hearing was called at 9 a.m. It is now 9:43 a.m. Defense, do you have any idea where your client is?
I have no idea, Your Honor. He was here last time.
And the court made the defendant aware that his next court date was today. State,
Your Honor, the state of Rupert bond.
that will be granted. Your client will be remanded without bond. If you're able to get in touch with him and you make an appearance, the court will reconsider.
Thank you very much, Your Honor. May I be excused?
Yes, you may be excused. Always a pleasure to see you, Mr. Seeloff.
I left my cell phone with this fine gentleman.
All right, thank you.
Good luck. You can go back to sleep now.
All right, thank you.
No, take good care, John, first, before you take your nap.
All right, is there anyone here who came late? Okay, and what is your name? Smith?
Yes.
Next,
Amberlin, Norwegian.
next,
John Carson.
anyone else? All right, Christopher Trinidad, can you come forward, please? All right, Mr. Trinidad, do you have a case number?
Caution,
Yes.
674-999.
All right, who's your attorney?
Ralph Leal,
Yes, have you had a chance to speak with Robert Leo?
if not, he's here. He said, yeah, they're going somewhere.
Okay, all right, just have a seat. He should be back.
Thank you, ma'am.
You're welcome. Okay. And Ms. Ferguson, have Mr. Leal come back. And Norma, I don't see Christopher Trinidad on the docket. Who's here? Leticia Lopez?
I am, Your Honor.
Yes. All right, with regards to this motion for a I guess a free record from the court reporter. Do you know, was this a plea of true? Was this an agreement or no?
It was a contested MTR, Your Honor.
Okay. And were you appointed or retained?
I was appointed.
All right,
What's
just,
the name on it?
just make sure a copy of it goes to the court reporter, okay?
Thank you, Your Honor. It's Leticia Lopez.
Okay, yeah, that's a different reporter. I think she's filed it too. Already.
Okay,
Yeah, that's Diane Ferrero.
okay.
Um,
Yeah, but do you?
Let me.
Don't talk to anybody out in us or they'll be.
Who's here on Christopher Garza?
I think it's in the file.
All right.
Okay, I'll check.
All right, Christopher Garza. Where's the defendant? All right, so everyone, if your client is in custody, you need to let the deputies know so they can call them out. Because we can't do anything on the record without the client being present. Sure, no problem. They're not ready. Okay, if you could start asking them whether their client is in custody or not. Who's here on Aaron Sturm? Aaron Sturm, who's here for her? Come forward. Is there an Aaron Sturm in the courtroom? If you're here, you need to come forward. Let me see which page she is on. Thank you, Michael. You're so awesome. I appreciate that. All right, so what's happening with this case?
Your Honor, we have conferred with the state yesterday and today. And we're unable to reach a plea bargain in this matter. And I guess our next step would be moved to trial. So I'll move to trial.
All right, so Ms. Sturm, the court will not accept any plea bargain agreements in this case, so you will be going to jury trial. Do you understand? And so that also means if on your jury trial date, the state decides to make a new offer, the court is not accepting that plea. So you will have to plea open to the court. So there's not going to be any pleas of, we're making them an offer of a lesser included. Today is the day. Okay. All right, Ms. Ferguson, I need a quick jury trial setting for Aaron Sturm, please.
I'm telling you, that's what they're saying. So they're trying to get rid of this one. And see what we can do. And we have to do the new one. I would defend that ruling if you're in. I'm not being charged.
All right, how long do you expect this trial to last on the state side?
Judge, 2 days.
Right down.
Okay.
Yeah, 2.5. That's right.
So your jury trial date is gonna be October 25th. You need to come dressed for trial. You understand?
Again, all in well. You're charged with.
And I need an acknowledgement of discovery before you all. Oh, actually, I found one. All right, is there anything that needs to be added to the acknowledgement of discovery? Because this one is dated June 2022.
I don't. I don't. believe so.
I haven't uploaded anything.
No.
Okay,
And I've checked everything before I go to court and sure I've gotten everything that needed to change. Nothing's changed.
all right, so you'll need to be here on June 25th at 9 a.m. for your jury trial.
Thank you, Your Honor. May we be excused?
You need a jury trial setting.
Okay.
Thank you. Who's here on Darren Doe's?
This one, this session already started, but with all the things. Just like, she's already like
All right, my understanding is all discovery has been received in this case. Today is your plea deadline date, Mr. Doze. Are you accepting the plea or no? All right, so the court is not going to consider any plea bargain agreements after today. So even if the state were to offer you something that's different, court is not accepting the plea. State, if you want to offer him something different, then now's the time to do so. Not time at the day of jury trial. Does everyone understand? All right, so state, how long are you expecting the case to last from your point of view?
Judge, maybe at the end.
Defense?
That sounds good, Judge.
All right. All right, Ms. Ferguson, I need a jury trial setting for Mr. Doze as quickly as possible. My understanding, it's probably going to be 3 days. So it's a pleasure seeing you, Mr. Calkins.
You too, Judge.
It reminds me of our law school days.
It's about the same. You're the judge and I'm the beat up. Just like in law school.
All right, we're going to be going to trial in my birth month. Okay. All right, is there any other matters that need to be taken up?
I don't believe so.
All right, so Mr. Calkins, with regards to jury trials in here, if there's some video that I need to see or something that needs to be suppressed, I don't like to keep the jury waiting. So if there's something I need to see beforehand, you all need to let me know beforehand.
Very well.
All right, Ms. Ferguson will give you a reset form. And thank you for dressing appropriately for trial. I really appreciate that.
Thank you, Judge.
Neil, did you want credit for that?
No, Judge, he did that on his own.
Okay. And just get the reset form, Mr. Kalfas.
Yes.
And number you said 11/20. 29, okay. Who's here for Christopher Givens? All right. And let me just find his page. All right, so what is happening with this case?
Your Honor, we need to reset. I've got, I had a challenge getting some of the videos to download. I think that's been working through. I just need to get them downloaded now and get Mr. Gibbons back. So we can talk about it.
Okay, when is that going to be accomplished?
I should have all the videos by the end of this week.
All right, and did the state make an offer?
We have an offer.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date for Mr. Givens. All right, so we're going to come back on October 25th. That's going to be your plea deadline date. So at that time, you need to let the court know whether or not you're accepting the offer tendered by the state. If you choose not to accept the offer, what's going to end up happening is you'll be set for jury trial quickly. You understand? Now, on that date, that is your final plea deadline date. So if you don't accept the state's offer at that time, or if the state doesn't accept any counter offers that's tendered by your counsel, the court will not consider any plea bargain agreements. You understand? I'm sorry. And the only exception to that, of course, is if there is some sort of new discovery that nobody has had. All right, thank you. Ms. Ferguson will give you a reset form for your excuse.
In jail, you've already got 100 days. For credit, you'll be thrown out of jail on this show. Or if he could keep you on probation, he does not have to discharge you.
Did you see Trejo on the docket?
Telling you, I'm warning you. We do this. It's possible for judge. Going to keep you on probation. It'll be
Not on mine.
Hello.
Nope. No, Trejo.
That should give you 100 days in jail as a sentence, which could be judgment satisfied. We still have that new case. They either will or they won't indict it. They will or they won't enhance it. If you weren't there, You're not gonna get much traction.
Is Trejo on the docket today?
Yeah, I don't see him.
I'm trying to take care of.
Can you
this
look that up
shit.
and see if that's on the docket today, please?
Oh, they're behind you.
Good morning. You need to get whatever you need from the clerk. You need to get whatever you need from the clerk. Okay, because I don't have the file, so I can't do anything. Who's here on Dane Cortez? Is there a Dane Cortez?
Yeah, that's the NPR. You're gonna ask it. You're gonna feed truth to this number 5. Okay.
All right, state on Dane Cortez, that's going to be recalled for Thursday.
Okay, I think that complainant wanted to be present, so I'll let her know.
All right. The defense attorney is ill.
Okay, thank you, Judge.
You're welcome. All right, so everyone, when you get your file from the clerk, I'm trying to keep this area as least congested as possible. Just have a seat. I'm going to call you in the order in which you appear. The last will not become first in this court. If you turn in your file first, you're going to be the first one that's called. I guarantee it. And state on Cortez, are you calling any witnesses?
Judge, if we do, it would just be one witness,
Okay,
and I don't anticipate their testimony taking place.
all right, thank you. All right, Deputy Laura, if you can let Mr. Cortez know, we're going to recall his case for Thursday. His attorney is ill.
Yeah, I mean, you kind of really are. It's like.
Where's the attorney on Janelle Trejo?
Right here, Judge.
Where's Janelle Trejo?
He's here, well.
Well, Janelle Trejo needs to come forward. You're there. She's in the middle. All right, today is the plea deadline date. What is happening?
Judge, this is the case where I made an offer at the last setting. Defense counsel brought me a letter indicating that she is currently in inpatient treatment, and I guess that's why her sponsor's here. I told him she's supposed to complete it beginning of October. I told him that if she completes it, that will change the offer. I think it's the case that we can work out. We're just trying to see how committed she is.
I mean, do we really need to do that? How long has she been? I mean, have you all talked to her sponsor state?
No, Judge, she just told me this morning.
Well, do you have any objections to the state speaking with your sponsor?
No.
All right, so maybe that'll make things move along quickly. So the state's going to speak to your sponsor. We'll see where we are. So just have a seat.
All right, I'll be
If
right
she's
back.
with her sponsor.
Yeah.
All right, thank you. All right, who's here on Rolando Garza? Rolando Garza, come forward. Has it been brought out?
No, Your Honor.
All right, then, once your client is brought out, then we'll take this matter up. Jane Green. All right, so what is happening with this case?
We're set for trial, Your Honor, on both of his cases. I believe the state, the priority I believe it's 880 case.
Yes, Judge, we plan on trying the sexual assault of a child first.
All right, so here's the thing, the court doesn't have an acknowledgement of discovery. And we currently have a jury trial, a jury that are deliberating, and I only have one jury room.
Okay.
And no other jury room is available for me, I've asked. So this is gonna have to be recalled for a different day.
Okay.
All right. So before either party leaves, I'm gonna need an acknowledgement of discovery completed, and I need an acknowledgement of discovery on each case.
Okay.
And then Ms. Ferguson, well, State, how long do you expect the trial to last?
I don't think it would last more than a couple days, depending on, defense's case, but yeah, we should be able to try it.
Okay, so the state, you should be finished with your case in chief in 2 days.
Yes.
All right. and then- All right, so Ms. Ferguson, can I have an early jury trial date for Mr. Green? And know that at the most, it'll probably be 3 days. And do you know if he were found guilty? Do you know where he's going to for punishment?
Jury.
And it's 3 days. All right, it'll be on Halloween, October 31st.
Okay.
Okay, and thank you for addressing appropriately for court. I appreciate that. And they will give you a reset point. And I'm sorry, Mr. Green, could you come forward just a moment, please? All right, so Mr. Green, I do understand that you are rejecting the state's offer, but I always like to have a date set for as a plea deadline date. So your jury trial date is October 31st, but that's also going to be your plea deadline date as well.
Understood.
All right. Okay,
Thank you.
you're welcome. You're welcome. Who's here on Jennifer Hernandez?
God, you're on.
All right, if you all could approach, please. All right, where is this on the docket? Because I don't see it anywhere on the docket.
That's me, Judge, NTR.
All right, thank you. All right, the court is calling 2020 CR 3968A, State of Texas versus Jennifer G. Hernandez. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
John Young.
And are you Ms. Hernandez? I'm going to show you a document titled Motion to Enter Adjudication of Guilty or Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Jennifer G. Hernandez who was placed on deferred adjudication in 2020 CR 3968A for the offense of theft $100 to $750 on June 10th, 2021 for a period of 1 year? Is that you? All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Jennifer G. Hernandez, did then and there fail to report to the supervision officer as directed for the months of January and February of 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, the state waives all other violations.
Any objection?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 180 days in the Bexar County Jail, and up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes,
All right. So state, what are you requesting?
Your Honor, the defendant does have credit for 100 days in the Bexar County
I'm
Jail.
sorry, how many days?
100 days credit in the Bexar County Jail. The state was going to ask for a judgment satisfied.
All right, defense, what are you requesting?
That's what we're asking for also, Your Honor.
So you all have an agreement.
I guess we did.
All right, so Ms. Hernandez, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record. What have you done since you've been on probation? All right, and I understand that and I appreciate that, but what have you done as far as your conditions are concerned? Because that wasn't a part of your conditions.
$60 on a one time, there was a fee of $50 on that page.
And what else have you done?
To try calling my probation officer, telling him what can I do, to, you know, to get back on track. Because I was in the talk to this one guy following me.
No, here's the thing. Probation in this court know how I am. And if you had made a contact with probation, then we wouldn't be here for your failure to report. And I am looking at the docket sheet. And this is my handwriting. These are conditions I wrote. So I know you were supposed to report and you did not. I know you have a drug problem and that has probably been taken care of. I know you owe $50 to the Easy Pawn Shop and you haven't done that, have you?
That's what I don't know how to pay. Should I go down to the pawn shop and pay the 50?
No, here's the thing. You would know how to pay if you report to probation, which you have not done. Have you ever reported to them?
I tried, that's right.
No, I'm not talking about trying. Have you ever reported to probation?
No, ma'am.
All right, so basically you've done nothing.
I tried, though, ma'am, but I-
Nope. You know what? My mom had a teacher and maybe this is wrong of their teacher, but it was back in a time before people had the touchy feelies. And when they would tell their teacher they did the best they could, and you know what their teacher would tell them? Your best's not good enough. So I wasn't even asking for the best from you. The only thing I was asking from you is you needed to report. I was trying to help you with your drug problems. Let me just tell you, I'm gonna follow the agreement that's been reached. But let me just tell you how your life is gonna go if you don't get your life in order. You're gonna continue doing the same thing that you're doing. You're gonna be back in criminal court, or either you're gonna end up using drugs and it's gonna be a bad batch and something bad is gonna happen to you. Or either you're gonna be wandering around the streets of San Antonio, homeless, no job, no education, right? So what you do with your life is completely up to you. You're an adult, you're not a child, nobody's controlling you. So if you decide to continue your life the way it is, it's not going to turn out right. And I tell people this every way, you know what? Life is so simple. And when I was growing up, you know what? My mom would set down rules, I would follow them. You know why I would follow them? Because that makes things so simple. If my curfew is at 10 o'clock, I'm not coming in at 10:30. I'm coming in at 10. You know why? Because I don't want to hear the lecture, which is what you're getting from me, a lecture. I don't want to hear that. And the best way for me not to get a lecture is to come in at 10. And then you know what would happen? I would get the praise because I followed the rules. And then my brothers would be late and I would just smile because they would get the lecture. And I would try to add my 2 cents into the lecture. So you're going to have to change your ways. You understand?
I understand.
So I'm going to grant the motion, find you guilty. And how many days?
100 days, Your Honor.
Sentence you to 100 days in the Bexar County Jail, give you credit for any time served. And there is to be restitution of $50 to Easy Pawn. And I'll show that the judgment is satisfied. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement And because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So here's the thing, Ms. Hernandez. By not completing this, you made your life extremely difficult. The reason why I say that is because this is what's known as a crime of moral turpitude, which means that anything that you want to do with the rest of your life that involves you getting a license, it's going to be very difficult for you. And this is going to show up on your record. You understand? All right, good luck to you. You're welcome. Thank you, Mr. Young. Do you think the magnolias are gonna bloom properly come next year?
The magnolia is doing much better than my grass.
Oh my gosh, my grass is in a bad shape.
And there's little chunks of it naked. And I think that's endemic. Of the
Do you have St. Augustine?
Yeah.
Me too.
and it's really frustrating.
My entire front yard has been dug up, but at least we're turning over soil, so it's good. All right, have a good one. All right, the court is calling 2000. Oh, you needed me? No. Okay. Court is calling 2000. All right, so everyone, here are the rule, another rule that's enacted. And this is to help Brenna out. Her area, you see the ledge? That's nobody's desk. That is her desk. Do not sit your items up there. Do not talk around her. Do not stand behind her, Mr. Locke. All right. Court is calling 2022 CR 6495, State of Texas versus Antonio Rios III. Can I have parties approach and announce for the record, please?
Daniel Espark from the state of Texas.
Gary Trek for the defendant.
Are you Mr. Rios?
Yes.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rios, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Excuse me, when we're on the record, there should be no talking in the box. Thank you.
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving the enhancement paragraph.
Any objections?
No.
All right, Mr. Rios, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on a possession of a controlled substance penalty group 1, 4 grams to 200 grams as a second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication will revoke, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
You believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. The state opposes your application. Did you understand that to be the plea? Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor. Right.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motion?
There have none, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Our statement submit was the market states exhibit 1 into evidence.
No objection.
Mr. Rios, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty if you apply for deferred adjudication. Are you proceeding with sentencing?
Well, do press PSI, Judge.
Are you proceeding with sentencing?
Yes.
All right. State,
Your Honor, just to clarify, my note indicated it was supposed to be a cap of 8 years. I don't know if that is fully in the paperwork.
oh, it's a cap of 8?
Yes,
So
Your
let
Honor.
me put down a cap because it just said,
8 years. Sorry about that, Your Honor.
all right, no problem. All right, state you're opposed to his application. Is there a reason for the opposition?
I don't have a file from me, but from my memory, I believe it was his criminal history. That's why we wanted to do PSI, just to maybe have a full background to understand.
Okay, what is his criminal history?
Again, Your Honor, I don't have a file in front of me. I do remember that was why I did the cap of 8.
All right, what is your criminal history? And you need to tell me everything. I'm sorry, I'm gonna need you to speak up a little bit.
Put back into the bed. And I went to the time to finish up all of that.
And then what? All right, does he have violent history, state?
Again, Your Honor, I don't have the full history in front of me.
Just alcohol and drugs.
Just 1 second, we're gonna find out.
Your Honor, from what I can tell, no violent history, at least here in Bear County, but I don't have access to the NCIC, TCIC.
No,
Okay. Did you guys run the NC?
So we had it in the file again, it's just because it was recalled. from yesterday.
Judge, if you'll give us a second, let's see if we can.
Okay, all right, they're gonna see if they have it. So just have a seat. But before you have a seat, if you drug tested today, what are the results gonna be?
I've been concerned since,
Okay, all right, just have a seat. We're gonna come back to your case.
Thank you, Your Honor.
Who's here on Tyrell Shirley?
I am.
Hello, Mr. Cox, are the dreams with Florida now nightmares, or, I mean, what's going on with Florida?
How about much?
So you think, it's still,
Dream is still alive.
it's still alive.
Tennessee this week. Super week, and then we have. LA.
Yeah, we'll see what happens. I don't think LSU, all of this late excitement. That's something different. Brenda, do you see Miss Shirley on the docket? On what page?
Let me.
I found it.
Is this gonna be on the record? Is this on the record?
No.
Okay.
Sure. All right, Miss Shirley, they are telling me that they are dismissing your case. Well, here's the thing, don't go out, you know, people always want to celebrate or something, don't do that. I don't want to see you back here unless you're coming to visit in person just to see the court system. See your picture. Oh, thank you. You just made my day. And thanks for dressing appropriately for court. All right, thank you, Mr. Cox. Thank you. All right, who's here on Michael Teo? All right, hello, where's Mr. Teo? I haven't seen you outside, really outside of Zoom, so I'm used to you being in the square.
I saw you yesterday.
Oh, what?
You told me to be here first thing 9 a.m. Here I am.
See, but it's 10:20.
I was here.
I know, but they didn't, you didn't have it.
That was one of your better ones.
Huh?
That was one of your better ones.
Oh, thank you. Okay, so what is happening with Mr. Teo? Is there someone from the state on Teo? Because,
I'm here, good.
all right, because the last date, he was supposed to be scheduled for jury trial on August 22nd, but then,
We're here on a bond issue, Your Honor. I had approached the court last week, I believe on Thursday or Friday, and the court had informed me that we needed to have his criminal history and have a full hearing.
yes, thank you.
So I believe the court ordered to be reviewed for a PR because I was put this way.
Yes, and have you all had a chance to review the PR bond?
No, Judge.
No, Your Honor.
Okay, so what I'll do, and I know I said I have you out here, if you want to go to the back, just have them make a copy for you and the copy for the state, and then we can discuss it. Who? What page is it? I think they're supposed to be confirming.
Oh, okay. She's on the docket. She's on the now.
Okay, let me put Bailey on here as well. All right, yes, they're still confirming. No, that's not done. It just needs to be.
That's all.
All right, who's here on Amber McLagoon? I know I'm mispronouncing that name all over the place.
Morning, Your Honor.
All right.
I meet us for Ms. Milligan.
How do you pronounce your last name? Malujan. See, you were off, I'm off. Let me just see which page she is on. I'm sorry, what? Thank you. All right, Ms. Malujan, why were you late for court?
Today,
Yes.
parking and downstairs, I took a while to get in here, and I was next door at the wrong courthouse. when we first arrived.
Okay, so here's the thing, you've been here before, and we've had a no-show on you on August 23rd. I'm not gonna tolerate any more late appearances. Do you understand? All right, Ms. Ferguson, this is supposed to be a PTE, is that correct?
Yes, Your Honor.
All right, so what date, Ms. Ferguson? All right, we'll see you on Halloween. Make sure that all the documents have been filled out.
This is for your plea
All right.
bargain.
Yes, you need to get a reset form from Ms. Ferguson and don't be late next time. Rolando Garza. All right, who is the state on Rolando Garza?
I can fill in, Judge.
Thank you. Where are we on discovery?
Pending discovery. What do you?
Yeah, sorry, Judge. I just emailed the detective again today. We're missing a few different items in this case. We're missing a couple different videos and then some results from the crime lab. I emailed him last week on the 15th. He was gonna follow up on some of those items that day. I haven't heard from him, so I sent him another email this evening. This is a very evidence heavy case, as I mentioned before, so we're just trying to get everything.
And are you proceeding on the kidnapping first?
Yes.
All right. Do you have all the discovery in the theft case?
Well, they overlap, so
It's in the same day.
yeah.
All right, because I don't want us to come back and say, we don't have any discovery in the theft.
What's the
case.
same, it's the
Yeah.
same case, basically. Two allegations.
All right. So I don't think your attorney wants you to speak, but if you want to speak to me, I'm willing to hear
Your
you.
Honor, at this time, I want to waive my Sixth Amendment right to counsel.
He doesn't have anything else, so it's not that long.
Okay, we'll take that up after you have discovery. You want to go to trial without the discovery? Because I will tell you this, I've been a defense attorney, I've been a prosecutor. And sometimes people's defense is people are not going to show up for court. And I can't tell you the number of times I've been a defense attorney and people who are not supposed to show up to court come walking into court swearing them in. And I would always lean over and say, oh, is that a ghost that's on the witness stand? Are my eyes betraying me? So here's the thing, you're getting all your discovery. And state, when do you expect discovery to be had?
Judge, I would hope that we would have it within the next 30 days.
All right, so Ms. Ferguson or Ms. Garza, we're gonna proceed with discovery in 30 days. And on that day, if you don't have all your discovery, then somebody needs to have witnesses here to testify as to why they don't have the discovery and where it is. Okay. Yes,
The state has had over 8 months to have all this discovery.
Mhm.
I'm being held against my liberty. They don't have no evidence, Sean. They haven't proved no evidence, they haven't provided no evidence.
Mhm.
My bond's at $220,000, Sean.
Mhm.
All right, that's excessive. That's an excessive bond right there.
okay, here's the thing, what you're stating to me are conclusions, you're not giving me facts. So for example, I can say, there was rain yesterday. All right, then what are the facts to that? You know what I mean? So when you say things are excessive, then what are the facts of that? Just telling me your bond is at 200, well, time out. Just telling me that your bond is at $200,000 for a kidnapping is not per se excessive. I don't know any of the facts. Defense, if you would like to file a motion for a bond reduction, then what will need to happen, because they're based upon the new rules, I'll need certain information. So if you want to request a PR bond, I'm not going to grant a PR bond, but the PR bond will give me all the information that I need to make a decision on his application for a bond reduction. So if you want to do that and request that, you're more than welcome to. All right, Ms. Ferguson. What date? All right, so we're going to be back on October 28th for discovery. State at that time, if you see before October 28th that there's some issue with discovery, then witnesses need to come and testify to explain to the court why discovery is not here.
Yes, Your Honor.
All right, and then just Norma, on Mr. Rolando Garza, just request a PR bond so that I can get the information I need, and please don't have the clerks give it to me as though I need to make a ruling on it. It's just going to be for a PR bond. All right, is there anything else? Anything else, Mr. Garza?
Other than me wanting to waive my right to counsel,
All right, thank you for expressing your opinion for us. And you probably need to rethink that, but that's completely up to you. If you want to go to a jury trial representing yourself, you may do so. But let me explain something to you. Every attorney that you see here, because this is Texas, they at least have an undergraduate degree and they have a license to practice law, which means they went to law school. I have 3 degrees, but they went to school for that. And it took them no less than, maybe if you were pushing in undergrad the way I was, maybe 6 years. So they spent 6 years getting their education. I know that sometimes people think, that's an attorney. All they're doing is talking, but there's knowledge behind that talking. All right, so good luck to you.
Thank you, ma'am.
You're welcome. Right, let me find him. Who's here on Jesse Salinas?
That's me, Judge Parker Butts.
All right, where's Jesse Salinas?
Yes.
Come forward, please. All right, Mr. Salinas, they are dismissing your case. All right, good luck to you, Mr. Salinas. I don't want to see you back here unless you're coming to visit.
Yes.
Thanks, Judge.
Have a good day.
You're welcome.
Judge, I think you've got that info on it.
Okay, just give me 1 second. And then after that, if you all are ready on that bond case, I'll take that up. All right, we're back on the record in 2022 CR 6495, State of Texas versus Antonio Rios III. All right, so we're in sentencing. Does Mr. Rios have any violent criminal history?
No, Your Honor, he does not.
Okay, so what is his criminal history?
Your Honor, so he does have, as you mentioned, the DWI, which a few years ago, he was convicted on that. He was convicted on a possession case. He was originally granted deferred back in 2019, but then his probation was revoked back in March of 2021. He was sentenced to 2 years DEC. That was less than a year ago from his current offense.
All right. So, Mr. Rios, you've already previously been sworn in by the clerks. Are you employed? What do you do?
I'm doing punch out right now for pension.
I'm sorry, could you speak up?
I'm doing punch out man.
What is punch out?
I do all the main jobs for company, like the building, they're building new houses.
Oh, okay.
And so all the little stuff that they need.
All right. Do you have any children?
Yes,
What are their ages?
my son is 26 and my daughter's 25. You have a baby brain, but right now it's,
So, how do you spend your spare time when you're not working?
well, when I'm working, I can fix it about 9 to 10 hours of my time, and then after that, I just stay at home and visit my granddaughter and my grandson.
All right. You said you've been sober since Mother's Day. What is
Yes.
the reason for your sobriety starting on Mother's Day?
Oh, well, it was a wake up call for me.
Wow.
I was having problems with my fiance. Well, we were just working at the time.
Okay. You're whispering and you're like talking very fast.
No, we used to be boyfriend and girlfriend before, but now when I went into jail, I told her, so now I'm trying to do a lot better friends.
Why is it that men propose to women when they're in jail?
This is a wake up call. Pretty much.
No, is it a wake up call or you just want somebody to put money on your commissary?
Oh, no, it's a wake up call. Especially since she has medical problems and I want to have
What kind of medical problem?
she got into an accident like 15 years ago. What she has surgery on her knees and her stomach before that.
All right, here's the thing, Mr. Rios, you know you better than I know you. I see it's all possession cases, none of it is delivery. If I give you your deferred adjudication, what's gonna end up happening is if you are revoked on that, you're looking at the full range of punishment, which is 20 years prison. If I were to sentence you today, I know the state is asking for a cap of 8 years. I will give you 3. So I don't know you other than in just meeting you now. Of course, I know you from, coming in court each day, but that's all I know about you. So you need to look in your heart and make a decision on whether or not you can successfully complete deferred adjudication. And I will put you on deferred adjudication for 6 years. So in your heart, if you know that you can't do that, if you want, I'll send you to prison for 3 years and do your time. And here we are.
I be able to.
Well, I mean, here's the thing, look deep inside. Don't feel that you have to say you can do it because it's in front of me. All right, or because it's in front of your attorney or for the state's in front of the probation. So it's completely what you feel you can do.
I need, so I can.
All right, so I'm gonna put you on GPS to begin with. And it will be GPS tracking so that we can make sure that you're doing what you're supposed to do. Yes, but even though it's GPS tracking, there's gonna be a curfew associated with it. All right, so his curfew is gonna be 10 unless he's working probation. So it's 10 p.m. All right, this is what the court is gonna do. 6 years deferred adjudication. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to do the triple T parenting. Okay, just turn it into probation. I'm going to do the triple T parenting since you do have young grandchildren, and I always say people can always learn something. There's going to be regular reporting by Zoom or in person. There's to be random UAs until further notice, or either you can do the drug patch. The drug patch is different because there won't be a random UA where they call you and say you need to come in. You'll have the patch and they'll remove that. And we're going to do random UAs or either the drug patch for 6 months. And if there are no issues with that, then we can go to regular UAs. I'm going to want field visits 1 time per month. There's to be GPS tracking, waive fees with a curfew of 10 p.m. There should be proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else you need?
No, Your Honor.
Judge, the only thing, are we putting a time limit on the GPS
Until further notice.
to further do so? Somebody have to file a
So let me just tell you, do not come for me to have GPS removal before at least 3 months. All right. Mr. Rios, is there anything else you need from the court in order to be successful?
No, everything's going very well right now for me. Looking forward to this.
All right, if there's something you need, be sure to let probation know. If there is, because you've been sober since Mother's Day, if you're maintaining that by going to sober meetings, you need to continue that. I always tell people, go to as many sober meetings as you need to go in order to maintain your sobriety. It doesn't extend the length of your probation. All right. All right, I'm gonna show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Just remain in court. They'll go over conditions with you. Thank you, State.
Yes, ma'am.
All right, what page is Rios on? All right, thank you. All right, we're gonna go back on the record on your case. Thank you. And it's on Teo.
Yes, sir.
All right, Mr. Teo.
Yeah.
All right, court is calling 2019 CR 12685, 2022 CR 5759, 2022 CR 5760, 2019 CR 12684, 2022 CR 5614, 2022 CR 5761, State of Texas versus Michael Teo. Could I have parties announced for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
None of us can't give for the defense. Your Honor,
Just
just
1 second. And are you Mr. Teo?
Yes, Your Honor.
All right, so which case are you requesting the bond on?
so just for clarification, the last 3 case numbers that the court read off were cases that have been closed because of re-indictments. And each one of those being 12684.
Slow it down. Court has to take it down.
2019 CR 12684, 2022 CR 5614, and 2022 CR 5761 are all the same case and are all closed because of re-indictments.
Okay, just 1 moment.
So the current case,
Oh, just 1 second. I'm sorry. So he only has 2 cases open, correct?
no, we had 4 cases, those being 2022 CR 5760, 2019 CR 12685, 2022 CR 5759, and 2022 CR 8111.
Just 1 moment. So I have 2022 CR 5760, correct?
Correct.
22 CR 5759,
Correct, Your Honor.
2019 CR 12685.
Correct, Your Honor.
And what is the other that is still open?
2022 CR 8111.
All right, the court doesn't have that file.
It's the final iteration, I assume, of the.
2022 CR 8111.
It's also that you're asking for the bond issue on today, correct?
It's one, yes. There's 2 of them.
And I will just write closed on this file, so next time I will know. All right, so which is the case that you are seeking?
So there are 2 motions that to set bond with the court. And there is a motion to reduce bond.
Okay,
And the motions to set.
just 1 second. I'm so sorry.
I move with the court's pleasure.
Oh, thank you. They're just bringing the other file. I didn't have it. All right, so which I see according to this 2020 CR 5760 is to remain without bond, correct?
Correct.
All right, and then
As well as 5759.
okay,
And I believe the court's file should have 2 motions. Where I discussed with the state about a possible bond amount. We were able to come to an agreement. If that helps the court.
okay, just 1 moment. All right. The court is in receipt of the interview for PR bond. Have both parties had a chance to review that?
Yes, Judge.
Yes, Your Honor.
And for the record, the court has received the PR bond evaluation report. And in it, it shows the defendant's prior criminal history. It shows whether or not the defendant missed any court hearings. That is in the document as well. And based upon the PR bond report, the court will be able to entertain any bond agreements from the state or the defense and make a decision on the bond application in each of the cases. So is there an agreement?
There is on 2 of the cases, Your Honor. I
In which
believe the
case?
court, that would be on 2022 CR 5759 and 2022 CR 5760.
All right, what is the agreement on those two cases? State, let's start with 2022 CR 5759.
Judge, it's my understanding the agreement was for 10K on that case.
And what about conditions?
Judge, we'd ask for full GPS.
We would ask for partial to allow him to work.
All right, I'm gonna do full GPS. If he has employment, then the court will reconsider. You can always approach on that.
We do have employment and we can get the documentation for the court, whatever the court needs.
All right, I'll need that documentation. So in 2022 CR 5759, the court will follow your agreement. And if you all can get that order to me, please.
It should, it doesn't include the GPS, but there is a motion of order in the court's file.
Oh, there it is. Thank you.
I trusted the court more than myself. So,
Yeah, sure.
Okay, and then on 2022 5 CR 5760, $10,000, is that correct?
Yes, Judge.
yes,
And the court will then follow your agreement, and there's to be full GPS.
That's what you're on.
Yes.
And this is for the last case, 8111.
All right, thank you. All right, and then the last case is 2022 CR 8111. Is there an agreement on that cause number?
I don't believe so, Judge. No.
All right, in that case, the defendant is charged with failure to stop and render aid, death. State, what are you requesting for a bond amount?
Judge, just so I can, for clarity, it is at 75,000. Is that correct?
Let me see. Yes, it's at 75,000.
Judge, we'd ask that it stay at 75,000, Judge. Mr. Teo has 4 felony cases. In addition, he has a prior felony conviction. In this particular case that we're looking at right here, he picked up this case while he was on bond for a burglary of building in front of your court. He picked up this new case in which someone, in which he is charged with leaving the scene where someone died in a wreck. In addition, after he picked up this case during the early part of 2000, he completely absconded. The court stopped showing up for court until he was arrested on 2 new felony offenses in May of 2020. I think at this point, based on his criminal history, based on the case he's charged here, as well as based on the fact that he's had numerous times where he's been out on bond and either picked up new cases or not shown up for trial, that 75,000 is sufficient to secure his presence at trial, which has been something he hasn't been able to do during the pendency of this case.
All right, defense.
Your Honor, Mr. Teo has been in custody since May. He has three daughters that when he is out and able to work, he does support them. And in fact, he does have 2 employment opportunities waiting for him. One a company called Anytime Plumbing, where he has worked there for 3 years prior. And another with a company called TE Incorporated, where he is a project manager. He also has 92 credit hours at Palo Alto College. He is attempting to finish his bachelor's in business management, which he would like to be able to get back to doing. He understands that he has made mistakes and that absconding was never the right thing to do. He does not want to run and will be able to demonstrate to the court that he can fulfill any conditions and requirements that the court will hold him to. And he understands that this is, he's never been the type of person in my experience, in my representation of him, to take this lightly or half-heartedly. He will be able to better assist counsel in description of the accident because they're given the scene without getting into any facts. There is no camera footage of the incident happening. And so reconstructing the accident with the only other firsthand account is going to be extremely helpful in order to develop a defense for Mr. Teo. He, by being on full GPS as part of the requirements of the other two cases, the court will be able to keep track of him and know exactly where he is at any given moment of the day. Even if that were to be downgraded to partial, the court will be able to find him at any given moment. That's the beauty of the GPS. I do not believe that he will be a threat to the community or others. He has tried to make these bonds as they have been set and has been unable to. And we would ask that the court entertain our motion in setting or reducing the bond to an amount no greater than 50,000.
All right, Mr. Teo, I found in my short time on the planet, which technically really is a long time because I tell people I'm in the twilight of my life
Yes, Your Honor.
because there's more time of my life behind me than in front of me.
Yes, Your Honor.
But it is very rare that people make mistakes. People usually make choices. They're bad choices,
Make bad choices, Your Honor.
but mistakes are rare. Not saying that it doesn't happen because I've seen mistakes happen. I'm going to deny the motion for a bond reduction. I'm going to add full GPS and waive fees. So where are we with regards to this case? As far as trial, as far as discovery?
The last setting that we had, Your Honor, the state tendered us the first offer that we have had in this case. And we are attempting to negotiate something that would resolve all global.
All right, so when is the global resolution going to happen?
Mr. Brewer and I talked yesterday, in fact, about setting up a time where he and I can sit down and just kind of go over everything. We would like to get that done. I'm unfortunately going to be in a week-long trial next week and Eagle Pass. And so I would ask that if the court would.
Oh, and how far is Eagle Pass from San Antonio?
It is multiple hours, at least 2.5. So
Oh,
I'm gonna be
that's-
out there for the whole week.
Well, you said multiple hours. I thought you were going to say like 6 or something. My drive home is always 6 to 6.5 hours.
Well, Eagle Pass is right there on the, it's right there on the border.
So
So
it's not that far, a couple of hours.
we're in the heartland.
If only my family lived a couple hours away, I'd probably go every day.
The worst one was I had a setting in Galveston one day and then the very next. Delaware.
All right, so this is what I'm going to do because I see that there are a lot of cases and there may be a lot of discussion that you have to have. So that global offer needs to be accomplished within 45 days because that's going to be your plea deadline date. And after that, it'll be jury trial. Ferguson, can I have a 45-day reset on Teo for a plea deadline, please?
And just for clarity, and I think Mr. Kempton did say, we have made him an offer. So I think it just any negotiations as to that offer, we have made the offer.
That's correct. The state has made an offer.
All right. All right, so November 14th is going to be your plea deadline date and state on that day, whatever doesn't have an acknowledgement of discovery, I'll need the acknowledgement of discovery for that day as well.
Of course, Judge.
And then, Mr. Teo, if you decide not to accept the state's offer or the state doesn't accept the counter offer, you'll be quickly put to trial. You understand?
Yes, Your Honor.
Your Honor, just for clarification, is the court also waiving the GPS fees in 2019 or?
Yes, all
2020?
GPS fees are waived.
Okay.
All right, thank you. It's always a pleasure seeing you.
You too, Your Honor. Thank you very much.
You're welcome.
No, that was.
So Brenda, what page is
Click
Teo
on the
on?
recall, Judge.
Thank you. Yes, I did.
No, it's.
All right, we're gonna release them to go to lunch at 11:30 and then we'll come back. All right, who's here on Christopher Garza?
Robert, after events.
Michelle Hayden for the state.
Yeah, you, excuse me, sir. Right there. Yes.
We also have a case,
All right, court is calling 2022 CR 8955, State of Texas versus Christopher Garza for the state,
Michelle Hayden.
for the defense.
Robert Ariana.
And are you Mr. Garza? All right, state, you filed a motion to adopt previous pleadings.
Yes, Judge, this case was previously indicted under cause number 2021 CR 6459. Both sides had filed several motions and notices under that cause number. So we would just request that those filings be adopted into this case number.
All right, and state, I mean, sorry, the clerks, I don't have the current file for this case. It's 2020 CR 8955.
Yeah. Well, I'm glad I can. Yeah.
It was just indicted last week.
All right, any objections to the adoption of the motion?
No objections, Judge.
All right, that'll be granted. It's 2022 CR 8955. So when was this indicted?
When was
The new case, yes.
last week? Wednesday or Thursday?
Okay. All right, so where are we with regards to jury trial on this defense?
Your Honor, since the case was just re-indicted, we're asking for our 10-day notice on this one in order to look at the indictment and see how it relates to our case and possible defenses we can come up with.
All right, so I'm assuming the charge is the same, is that correct?
Actually, it was the previous case was a 7-count indictment, aggravated sexual assault and indecency contact. And now it's a 2-count continuous sex abuse and indecency with child by contact.
All right, so because the state, Mr. Garza, because the state has re-indicted this case and the charges have changed, I am going to extend his plea deadline date. And so his plea deadline date will be the same as your jury trial date. Okay, Mr. Garza? Ms. Ferguson, I need a jury trial date and plea deadline date, please.
Yeah.
You say November 29th? All right, your jury trial date and plea deadline date is going to be November 29th. So that's when you need to let the court know whether or not you're accepting the state's offer. Do you understand? And after that date, if you decide not to accept it, then you'll be in trial.
Yes.
All right, thanks for dressing appropriately for a court. I appreciate that.
Thank you.
You're welcome. And you all are excused.
Thank you, Judge.
And keep those files. Who is here on Randall Hart? All right, is your client present or no?
He's not present, Judge. It's Rob Talk here.
Have you conferred with the state?
I have not.
All right, confer with the state.
Okay. Can I get a copy of the judge back?
You have a supplemental report in your Adobe for the same case.
All right, thank you.
Yeah, it's probably the higher head. This guy's on probation. He's being extended. So I'm asking.
Acting further.
All right, just one moment. Let me see.
Yes, ma'am.
Bashan,
Yes, John.
where did you send it? Because it's not popping up for me. Do you mind resending that, please?
Yes.
Yeah.
Mind if I just put it?
Yes, that would be great. All right, who is the person you conferred with, counsel?
Marcus Sanders, Judge, he has no objection.
All right, so let your client know that I'll consider his report by mail once he signs the extension, because he is due to expire in October and he still owes $16,000. So he needs to sign the order extending his probation. Now, I can have a hearing on that, but what I can tell you is, unless he's gonna pay that $16,000 before October, he needs to have his probation extended.
No, he's in agreement to that, Judge.
Okay, you want to call him and have him sign that so probation can get that?
Yeah. I can have him do that.
All right, if you can do that, and then I'll come back and entertain your motion.
Okay, now, let me see if they can, Adobe sign.
All right, who's here on Inger Sawyer? Inger Sawyer.
Yes, Your Honor.
Court is calling 2022 CR 7738, State of Texas versus Inger Sawyer. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Scott Hill.
Are you Miss Sawyer?
Yes, Your Honor.
Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Believe I have.
Court will find that the state is in compliance with discovery. Ms. Sawyer, I'm going to show you, if I can find it in here. Oh, there's no application. All right. Ms. Sawyer, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we called the motion to amend the indictment. We're asking to amend the underlying offense from assault to theft
No objection.
in both paragraphs A and B.
All right, any objection?
No, Your Honor.
All right, then that will be granted without objection. Ms. Sawyer, did you have a chance to confer with your attorney on the changes that the state was requesting to the indictment?
Yes, Your Honor.
Do you understand that's a substantive change?
I apologize.
A substantive change. It's an important change.
Yes, Your Honor.
It's a change that allows your attorney to have extra time to prepare for any plea bargain agreements in a para for jury trial. Did you understand?
Yes, Your Honor.
All right. So are you in agreement with proceeding? All right, in defense, have you had ample amount of time to confer with your client on this?
Yes, Your Honor.
And do you believe that she understands that she has extra time to allow you to prepare for trial if you so wish?
I believe she does.
And do you believe she wishes to proceed with this case?
Yes, Your Honor.
All right, Miss, sorry, I'm showing you what's entitled court
And Judge, I'm
admonishments.
sorry, we're waiving paragraph A and the enhancement paragraph.
Any objections to the waivers?
No, Your Honor.
All right, Ms. Sawyer, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? All right, everyone, if you could just give me a moment. Can I have the defense attorneys for the trial on Mr. PARADA?
I don't think they're in here.
You want me to
I'll reach
call
out
him?
to them, Judge.
All right, thank you.
I'll call him.
Thank you. All right. Did you understand, Ms. Sawyer, that what you're charged with then by indictment in the paragraph state is proceeding on is burglary of a building theft? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Sawyer, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand, according to the plea bargain agreement, the state is requesting that your punishment be assessed at 122 days in the Bexar County Jail. Under 1244 of the Penal Code, there are no applications and they will take in consideration clause number 685467. Did you understand that to be the plea bargain agreement? Defense,
Yes, Your Honor.
state.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, State Offer States Exhibit 1 and its attachments.
No objection.
Ms. Sawyer, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court is finding there is sufficient evidence to find you guilty and the court is finding you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, just that you follow our agreement. She's been in jail continuously for 122 days. Ready to get out, start the life.
All right, Ms. Sawyer, I read the police report and I see that mostly you're selling food items and toiletry. What's going on in your life?
5 years ago, a gentleman slit my throat, knifed him out of my brain. He cut me multiple times on my arms. I've been at the Haven for Hope since the hospital released me. And I talked to security that day. I had a rip in my pants. And I talked to security because the main part was closed. And being there so long, and being with the employees that have been there as long as I have, they give me some leeway. And so that particular day, like I said, that area was closed. So I went around back where I used to work during bus accident. Excuse me, it's just hard to keep up with the conversation.
No.
And I didn't see nobody, but I found some pens. And so I put pens on and I left my pens there. And when I seen the lady, I tried to pay her for them
All right, let me ask you
and I walked
this.
out.
So here's the thing, what are your plans with the rest of your life? Because, you know, I'm inclined to follow their agreement, which means you're gonna be released from custody, probably in the early morning hours. But when you're released, where are you going? What are you gonna be doing?
I'm going back to Chicago where I'm from.
All right, do you have a bus pass to get to Chicago? How are you gonna make that happen?
I have a daughter that's gonna help me do that.
So that she know you're being released?
She will when I get back and I call her.
I have been in touch with her. Her kids.
All right, so what are we gonna do about the transport? And again, I'm only here to pass your sentence that you agreed to. But I'd like for people before me, so they won't come back before me or any other judge for doing something that may put their liberty in jeopardy, to think about what are the steps they need to take in order to be where they need to be. So is there going to be a bus pass waiting for a Greyhound or a big bus or whatever it is?
I'm going to be calling her daughter as soon as she got checked.
All right. So here's the thing. If Haven for Hope will accept you back while you wait for your daughter to do the bus pass, you need to do that. And don't take anything that doesn't belong to you, even if people are giving you leeway, because sometimes people feel like you're taking advantage and then you may get some person who's not going to give you leeway. So just follow the rules, okay? All right, this is what the court is going to do. The court is going to sentence you to 122 days in the Bexar County Jail under 1244. Give you credit for any time served, taking consideration 6, 8, 5, 4, 6, 7. And I'll show that the judgment is satisfied. Is there anything else with regards to sentencing?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, good luck to you. You're welcome. All right. All right, if I could, everyone, we're going to take a 2-minute break because I need to discuss a trial matter with the parties on this trial, and I will be right back. If you all can meet me outside, please.
Do we need an interpreter?
Not until I get the drafted, but yes, we are gonna need one. All right, who's here on Valentine Schaefer? All right, if parties can approach.
Valerie.
All right, just 1 second. I'm just trying to find you on the docket.
He's on 16.
Thank you. All right, what is happening with this case?
Your Honor, the state's recommended. plea on this case.
All right. Ms. Ferguson, can I have a PTD date on Schaefer, please? All right, we'll see you back on Halloween. No costumes are allowed.
Thank you, Your Honor.
You need to get a reset form for Ms. Ferguson. Thank you.
Thank you.
Thank you. Who's here on Alejandro Alamans? Alejandro Alamans. Going once, going twice. All right, they're not ready. Xavier Rodriguez.
He's in custody.
All right, Mr. Rodriguez, come up, please. All right, what is happening with this case?
Your Honor, we made an offer. for this case in the PIC that wants to be on the misdemeanor.
All right, and when is the plea on the misdemeanor taking place?
I did, Your Honor, went to 7. I went down personally at 7 right now, and the coordinator's not in. I'll have to email her. But prosecutors were both in trial, and I couldn't talk to anybody, but I think I can get them in as early as maybe Thursday, obviously. That's what I hope for.
Okay, all right, Ms. Ferguson, let's recall this case then in 2 weeks. So we're recalling in 2 weeks.
That should work.
Okay.
Now, I've also told prosecution that.
All right, thank you. All right, so we're gonna come back on October 11th, but if everything is taken care of, Mr. Rodriguez, you won't be back here. I'll sign the dismissal when it's presented, okay? All right, good luck to you. Thank you. Who's here on John Anthony Garza? Are they parties can approach?
The case, there's some unindicted. Stuff.
All right, before we get to that point, I need to know why your client was late for court. Why, oh, and you guys are in the wrong space. And I can't hear you. You need to speak up and stop chewing gum. And don't swallow it. We were told in school, if you swallow gum, it will mess with your intestines. I don't know if that was true. Yeah, that's what they would tell us in elementary school. So. All right, I don't know if that's good or bad.
I was trying to go and visit her for, but wasn't able to make it. And I was outside, but
There's some services to the judge, and I talked about that earlier this week. I told him regardless, we need to be there.
I was outside.
Well, if people would have told me about services, I allow people, I'm not a cruel person. I'll allow people to go to their services.
Yeah, I just was told I wasn't being able to.
Okay. When are the services?
It was today, but
All right, well, nobody informed the court. I allow people to say their goodbyes. All right, but here's the thing. Your grandmother hopefully knew that you loved her and hopefully you expressed your love to her, because usually they know. All right, so what are we doing with Mr. Garza? Where are we?
So there's an indicted debating case.
Mhm.
At the last setting, I was on the pending family office cases. I've been court of family violence, they still have not been able to make contact with complainants. I would hope that we recent this couple of weeks, maybe we can reach out and we can have a decision made at that point.
All right, and I do have my notes that you were recently appointed. All right, so Ms. Ferguson, can I have a 30-day reset on Mr. Garza, please? Is that enough time?
Yes, sir.
All right, so we're going to come back on October 24th. And Mr. Garza, next time if there is a matter, just have your attorney let the court know. All right, you are excused. All right, who's here on Justin Gonzalez? Just one moment. That are in the hallway. Yes, yes. Oh, not the jurors here. Lupe, what is this on the file? You just passing me stuff? Oh, let's have them come back at 1:30. All right, the court is calling 2022 CR 6213, State of Texas versus Justin Gonzalez. Can I have parties announced for the record for the state? For the defense?
Kelly Fiddle.
And are you Justin Gonzalez? All right, counsel, I'm going to show you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. All right, everyone in the jury box, when we're on the record, you all need to stop talking. And everybody don't congregate or lauder around Brenna. And state, that's Brenna's private space.
This is not mine. I can move it.
That part is fine.
Nope, see, once you give people an inch, sometimes they take a mile.
Judge, I'm gonna put it right here.
So Brenna, when
It's really just right behind me. Don't close me in over here.
I'm closing you in. Brenna, when I say the defense can't do it, the state can't do it either. We are a fair court. All right, Mr. Gonzalez, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
I believe so, Judge.
They're waiving count one, Judge.
That sounds right.
All right. Any objection to the waiver of count one?
I'm sorry, Judge. I didn't
Oh, no,
do the
no.
paperwork on this.
No, I appreciate you standing in. Mr. Gonzalez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
You understand the state is proceeding on count two. And count two is an aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision because you're not eligible for community supervision, and sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 2, which is an aggravated assault with a deadly weapon. There's a $1,500 fine, affirmative finding of deadly weapon. They're recommending deferred adjudication. This is to run concurrent with the DWI case number 661512. They are taking in consideration county court cause number 651279, 651280. There's an affirmative finding of family violence, and there's to be no contact with Roman Ruiz. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement?
Yes.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver Repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Your Honor.
Counsel, have there been any such motions?
No.
Off the record, can you let Caroline know I'm sending something back to her if she could please print it? Back on the record. Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 7 years. There'll be a TAP evaluation, 150 hours of community service restitution. You to follow recommendations of TAP, MILF evaluation, parenting classes, hostility, aggression course, and UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Off the record. Can we make sure that the interpreter is here because I have an answer to the question? Thank you. All right, we're back on the record. Then to offenses indicted in count 2, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Yes, Your Honor. At this time, state up for states exhibit number 1 and its attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And just let me know when the interpreter arrives. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, just ask you further.
All right, so Mr. Gonzalez, have you ever been diagnosed
No.
with mental health issues?
No.
All right, so why are you pulling the knife on your brother?
There was just an argument. It was an argument.
Well, a lot of people have arguments and they don't pull a knife on anyone. And there wasn't even a dinner at the table. You just pulled a knife.
It's my brother. That's another thing that is worse. And I apologize to him already. I spoke to him.
Well, I mean, it's your brother, so that makes it bad because your mom is probably hoping that her siblings would not attack each other, right?
Yes.
And then what else makes it worse is that your mom is actually taking care of your daughter, which is something you should be doing that you're not doing. So why does your mom have custody of your daughter?
I guess because my
No, it's not. I guess everybody knows why they don't have their children. So why don't you have custody of your daughter?
have custody because my baby mama didn't let me have.
Okay, let's not say baby mom. Let's not use that term. Let's say the mother of my child.
Mother of my child, she didn't let me
Well, why doesn't the mother of your child have custody of her child?
because I'm behind on child support.
No, 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 no. There's a reason why biological parents don't have custody of their children. Sometimes they put them up for adoption. But in your case, there is something else going on that your daughter would not be placed with her mother, and instead she's being placed with your grandmother. So was Child Protective Services involved?
No,
That's either yes or no.
no,
So they want a mouth evaluation, and you're saying you don't have mental health issues?
I don't,
All right, so what's the reason why you don't have custody of your daughter?
because I'm not stable.
All right, and what does that mean, you're not stable?
I don't have my own place yet.
Well, no, I mean, it's more than you not having your own place, because how old is your daughter?
She's 9.
All right, she's 9 years old, and you haven't had custody of her. So it's more than you not having a stable place. So was there drugs involved? What's going on?
No, it's just I just have.
All right, let me explain something to you. You have entered a plea on this case.
Yeah.
You're going to be placed on probation. I have sent people to prison when they didn't follow through on their contract with the court for their probation. I take no pleasure in sending people to prison. When I place people on probation, I'm hoping they're going to be successful. They're going to do everything. They're going to end up going off in the sunset, enjoying the rest of their lives. And this is just going to be a bump in the road. But if you're not honest with me, guess what? I'm going to send you into the world like a newborn baby without any protections and any support. So I'm trying to figure out, and I need you to be truthful to me. What are your issues?
I had a drug problem.
And what was the drug of choice?
I was heroin.
All right. There you go. See, that wasn't hard. I always tell people where you are right now in this orange jumpsuit coming over from the jail. This is not where you're going to always be unless you choose that. Okay. So have you ever been employed?
Yes.
All right. What have you been doing?
Well, I'm a truck driver.
All right. Is there any gang affiliation?
No.
All right. Who did your tattoos?
Who did my tattoos?
Yes, which they're beautiful, by the way.
Thank you. Yeah, I did them over in Laredo.
Okay. All right. There's a lot of ink masters would say, as I watch ink masters, the feathers are so great on the headdress.
Thank you.
Okay. All right. So this is what the court is going to do. I'm going to follow your agreement. It's going to be 7 years deferred adjudication. There's a $1,500 fine. That will be probated. There's an affirmative finding of a deadly weapon. This will run concurrent with 661512. Taking consideration 651279, 651280. And I'm sorry, back with regards to your plea, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes. Yes,
And
sir.
did you also understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Sure.
All right. And knowing that, do you still wish to continue with this plea agreement? All right. So there's an affirmative finding of family violence. There's to be no contact with Roman Ruiz. So that means no phone call to him or anything. Later that can change, counsel, if things are working out. I'm going to ask for parenting classes, and that'll be triple T. There's 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I normally would waive the remaining community service hours for the parenting classes, but in your case, I think you need to stay busy because I'm concerned about the drug addiction that's going on and the lack of responsibility you're taking for that. We're going to do a TAP evaluation. Follow all TAP recommendations. And that TAP evaluation is going to take place while in custody. We're going to go ahead and do a referral to felony drug court. I know that some people will say, He's charged with an aggravated assault, maybe felony. Drug court won't accept him for that, but they look at it on a case by case basis. We're gonna do Mick Myoff evaluation while in custody. There's to be hostility, aggression course. There's to be random, well, we're gonna do the UA hotline until further notice. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be regular reporting by Zoom or in person. And I'm going to want field visits 2 times per month, random. And the defendant is not allowed to live with his mother. So the location of this incident which is Oak Island, is that correct? All right, the defendant is to have no contact with Oak Island Drive. And defendant is not allowed to reside with his mother. And the person who lives at that house, is it just your mother? Or is it your grandmother too?
No, my brothers live there and my stepdad.
All right. All right, he's not to reside with his mother or his stepfather. Is there anything else that he needs probation? Is there anything that you need from the court in order to be successful? Anything else? Showing what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Gonzalez, your mom and stepfather and your brother are taking care of your daughter. That's something that you should be doing, but you didn't step up to the plate, so they did. So you should be making their life easy. And let me explain to you, one of the reasons why I'm not letting you live with your mother and your stepfather, because I don't want any family animosity or confusion because you're to have no contact with your brother. So you can let them know that I said that you can't live with them. And it's not your brother's fault. You understand?
Yes, Your Honor. And,
All right.
I'm looking forward to taking care of my daughter. I've made a lot of changes while I've been in jail.
All right, so here's the thing with that. A motion's gonna have to be filed because I said no unsupervised contact, and I'm not gonna allow you to have contact with your daughter or have your daughter stay with you. And then the next thing I know, you're bringing some new woman in the house to be her stepmom. I'm not gonna allow that. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you. Thank you.
All right, could I have the attorneys on Jose Parada, please? And we have the interpreter here.
Yes, Your Honor, I'm here.
Thank you. And you're still under oath.
I am.
Okay.
Always.
All right. Court is calling 2021 CR 7575, State of Texas versus Jose Parada. Could I have parties announced for the state,
Ryan Groomer and Marcus Sanders.
for the defense?
Guillermo Lara and Matthew Allen.
And for the record, Mr. Parada is here and so is the interpreter, and the interpreter is still under oath. The court received the following question. What is the minimum or maximum the court can assess for community supervision? The court proposes the following supplemental charge. The court has received the following question from you. What is the minimum or maximum the court can assess for community supervision? You are instructed that if the jury recommends to the judge that the judge place the defendant on community supervision, the judge shall place the defendant on community supervision for any period permitted under the law and as appropriate. In this case, under the law, the minimum period of community supervision is 2 years, and the maximum period of community supervision is 10 years. Any objection to that answer, state?
None from the state.
Defense?
No, Your Honor.
All right. The court, any objections to the court sending this supplemental charge to the jury in the back Or would you all like the juries brought out to have this read? State,
Mistake, we're okay either way, but if you want to send it back, we don't have any objection to that.
defense.
No objections, Judge.
All right, Deputy Laura. Thank you. All right, who's here on Jonathan Tate? Mr. Tate,
Some custody.
come down, please. All right, what is happening with Mr. Tate?
Judge, I've been given an offer today. My client is going to think about it. Same time, and there's still a lot of videos I need to see, so I'm just requesting one reason.
All right, so, Mr. Tate, would you like us to have you brought back in 2 weeks for you to think about the state's offer, or do you need more time? I can either bring you back in 2 weeks or I can bring you back in 30 days. It's completely up to you. 2 weeks? Okay. All right, Ms. Ferguson, can you recall Mr. Tate for 2 weeks? All right, Mr. Tate, we're going to see you back on October 7th. At that time, will you be able to let the court know whether or not you're going to accept the plea? All right, thank you so much. So we're going to bring you back on October 7th, and that will be your plea deadline date. Thank
Judge.
you. Who is here on Valerie Castillo?
That's me. Judge, I don't,
Valerie Castillo, you need to come forward.
she just arrived, Judge.
All right, well, then she has some explanation, right, for me. Brenda, do you see Miss Castillo on the docket? Ah, I found it. All right, Miss Castillo, why were you late for court?
I live in Atascosa.
I'm sorry, what?
I live in Atascosa and like,
And how far is Atascosa from here?
I don't know from here. I know from Frederick, but they just told me.
No, I mean, you know, because you got here from Atascosa County. So how far is Atascosa from here? 30 minutes? So here's the thing. Atascosa County is 30 minutes away from here, and you showing up to court after 11, that's an issue. So what that means is something happened at your house that you didn't wake up, or something happened.
I woke up at 6 in the morning, but I had things, I was doing stuff, I was multitasking at the time.
I can't understand a word you're saying.
Multitasking in the house, I had stuff to do, so like, I was doing that at the same time I was getting ready.
All right, here's the thing. I can't have people showing up late for court. So if you show up late for court, there's a potential that we will help you be on time for court. And you know how we will do that?
Sure.
How? Yes. And the deputies will have you brought over. And guess what? You'll be in the box at a time when your attorney is here, and we'll make sure that you're on time. Do you want to see that happen?
No.
Then your multitasking should be in an alarm clock and setting. Okay? I'm going to note in the file that you were late. All right, what are we doing with this case?
Judge, I just got an offer from the state. I didn't think she was going to show up in time before I left, but we could reset that to the same day, October 7th. That'll give me time to go over the offer with her.
All right, your new court date is going to be October 7th. That's going to be your plea deadline date. Do you understand? All right, good luck to you. Don't be late again. Who's here on Jorge Terrazas?
That's my last one, Judge.
You are just like back to back, and they're all on the same page.
Ms. Castillo?
All right, Mr. Terrazas, you need to come forward.
Judge, I have not heard from him. I left a message.
No, he's right here.
Oh, it's here?
Yeah.
Oh, well, Judge, I didn't think he was here today. I had.
All right, then I'll let you confirm.
Thank you, Judge.
You're welcome.
Sorry. Called out your name earlier.
Oh, I went through it.
Mr. Hill? She has to. Who's here on Aaron Trevino? All right, bring Mr. Trevino down, please. All right, so Mr. Trevino, you're actually scheduled for trial today. However, we still have, as you've surmised, hopefully you surmised, we still have a jury that's out and the court only has access to one jury room. If I had access to more jury rooms, I would just line everybody up and we could take this whole row and we could have like 3 juries out at one time. Well, actually, we have 1, 2, 3, 5 prosecutors. We could have 5 juries out at one time, but we only have 1 reporter, but
I only have 1 liver too, Judge, so.
But Brenda, I think you could do it. So we could have 5 jurors out, 5 jury trials going, but we can't do that because I have no place for them. So where are we on this case? Does he still want his jury trial?
Yes, Your Honor.
All right. And which page is he on? Aaron Trevino?
And Judge, I typically this is gonna be a longer trial.
Okay, so you anticipate this is going to be a
longer trial, yeah, we have multiple doctors. On this case.
All right. So how long are you guys anticipating?
I imagine the state's case would take probably 2 days. I know it's not super long, but I think if we had 2 full days, we can get done, but it's, half
All right.
days.
So we'll have all of Wednesday, more likely than not.
Mhm.
And then, of course, we have all day Friday. All right. So Norma, what's a jury trial date? It's probably going to take 3 days total. Yeah. And Mr. Cabanas, I'm sure you're on the civil side. When people make time announcements, they just cut you off. If you say it's going to take 20 minutes, at 20 minutes, it's like, okay, we're done.
But Judge,
But-
I amend my position.
But here you can go as long as it's needed. And how long do you expect your side of the case to last?
Judge, I don't anticipate we're gonna have any witnesses
Okay.
on the defense, maybe rebuttal witnesses, but at least I think the 3 days is. enough time.
Okay, so it'll be a 3-day trial. And everyone, the court is taking its lunch break at 12:15. So please do not approach at 12:14. Let's do 12:15 because everybody needs lunch. And I'm being told that some on the staff get hangry when they haven't eaten.
I don't know who we talking about. Judge.
See, I just say some. Yeah. I just some. No, oh no, they just need, not November 8th, yes. Brenda, I'm saying some because I'm excluding myself. All right, so your jury trial is going to be November 29th. And Mr. Trevino, if I had a day that was sooner to put you on the docket, I would put you on a day sooner. But there are limited staff and limited resources, okay? All right, is there anything else from either side?
Nothing from the fence, Your Honor.
All right, thank you.
Thank you, Judge.
Thank you. Who's here on Robert Cuellar Lopez?
Jason Goss, Your Honor.
And where's Mr. Cuellar Lopez?
Just went to the bathroom. We have a PTD application. They've offered PTD. We have an application.
We'll wait for him to come back.
Yes, Your Honor.
All right, thank you.
Sure.
Who's here on Jonathan Boyd?
Hey, Your Honor.
All right, your client was late. He's doing a disservice to the last name Boyd.
Understood.
And Brenna, I just lost my pen. Yeah, I think so. Let me see if this one will work. The point just disappeared. Yes, I do have another one. All right, so where are we on Mr. Boyd? State? This is CP, I'm sorry, this is family violence.
Michelle Hayden for the state.
All right, so I see that you all have the CPS records that I'm signing the release for.
Your
Is
Honor,
that
I got them today
all right?
and I have them in my pocket here.
Okay. All right, other than the CPS records that were just tendered today, is there any other outstanding discovery?
Your Honor, we do not believe so. There is a child safe video that we still need to come in and view in the office, but we will do that as well as look at the.
All right. And the court received a discovery acknowledgement dated in April. So is there any updated discovery state that we need another discovery acknowledgement?
I don't recall if anything else has come in between now and that time. Obviously, we did turn over the CPS records today, though. We can go ahead and do one if the court would like.
I mean, it's completely up to you all.
We can write it in on that one. You can just write the date that they would.
No, because it's been file stamped. All right. So Norma, can I have a jury trial date and a plea deadline date for Mr. Boyd? All right, it's going to be November 29th. And here's the thing, Mr. Boyd, I'm writing in my file that you were late for court. If you're late again, what's going to end up happening is we're going to make sure you're on time. And you know how we accomplish that?
Yes, ma'am.
In custody. All right, they're going to give you a reset form.
And Judge, Mr. Cuellar, the client is back in the bathroom.
All right. Mr. Cuellar. All right, on Cuellar Lopez, come forward. All right, so you're saying this is going to be a PTD?
Yes, Your Honor, the state's offered PTD. My client, I've discussed it with him. He will accept. We have to do the application, and I believe Norman has already given us a date.
And what date?
Halloween.
All right, we'll see you back on Halloween.
Thank you, Judge.
Thank you. Brenda, I'd like to say, we'll see you on Halloween. Matthew Salazar.
You see, Judge.
All right, come forward. Look, you say your name twice and we're here. All right, what is happening with Mr. Salazar?
Well, an offer was made that.
And Cadiz, you have so many files. You are the hardest working attorney in San Antonio and surrounding counties. Where's your briefcase?
It's in the car.
In another court. All right, so what is happening with Mr. Salazar?
They made an offer to it.
All right, and Matthew Salazar, why were you late for court?
Right there. Oh.
No. I called the docket and there was no response from you. And you know why I know there was no response for you at 9 o'clock? Because I write initials when I call the docket and it says NP. And you know what NP stands for? Not present.
I just don't know if I was sitting next to my father when you called me.
You were late. Are you Matthew Salazar, cause number
Yes, ma'am.
2022 CR 3264?
Yes, ma'am.
You're late. Here's the thing, you can't be late again. You understand? If you are, we can assure that you'll be on time and you know how, right?
Yes, ma'am.
All right. So don't let that happen again. So where are we on this case?
Well, they made an offer, Judge. We were still in that area of looking at discovery and those types of things.
Okay. All right, Ms. Ferguson, can I have a 30-day reset on Mr. Salazar? And it's just a regular reset. All right, we're going to come back on October 25th. And what's going to end up happening on October 25th, when you come back, you can enter a plea if you so choose. If not, I'm going to give you a plea deadline date. And then your next date after the plea deadline date is going to be a jury trial. You understand? All right, is there anything else from either side?
No.
All right, thank you. Santon Wilson. And Brenda, what page is Mr. Wilson on? Thank you. Yes, it's in Wyson or Wilson.
Wilson.
Yeah. All right, where are we on this case? Because we're here for a jury trial date and today is his plea deadline date.
All right, well, we, I don't think, at this point, I don't think he's going to accept the offer.
Are you accepting the plea offer?
No.
All right, so your plea deadline date has expired. The court will not accept any plea bargain agreements in this case. Do you understand? All right, Ms. Ferguson, can I have a jury trial date for Mr. Wilson? And state, how long do you anticipate your case to last on Mr. Wilson?
2 days, including jury selection.
Okay. So they're saying they can do it in 3 days. Is this like name that tune? I can name the tune in 2 notes. You remember I always, this is why I like having you in here because you and I remember all of the. I remember there was one guy on there, he could name the tune in 1 note. And then somebody's like, I could name the tune in 0 notes because they understood the clue.
So, well, if they can do it in 3, Judge, then I hope, if they don't, is that an acquittal?
Marcus,
No,
Mr. Cox wants to know if you all cannot try this in 3 days, is it an acquittal?
no, Judge.
Okay, so I'll take a day, so if they can do it in 3, I'll tack a day on for me.
Okay, which date, Ms. Ferguson? All right, we're gonna call you back on November 1st. All right, Mr. Cox, you'll be trying the case with me on my birth month, so I appreciate that.
Okay, good. All right, just on that, when I called, you called earlier on the, okay, you said that.
Who?
Matthew Salazar, you just called.
Yes.
For some reason, Judge say he's on ELM, and he was on the ELM, and he was on the, allowed him to own parking. Might change it. And he has school today, and they.
All right, who is the prosecutor on Salazar? All right, Mr. Cox is saying his GPS conditions were changed. And he has school today and he's not being allowed to go to school?
When were his GPS conditions changed? Because he. Very recent.
That's probably why if he picks up a new case. So if you want to have that heard, Mr. Cox, we can hear that very quickly, but just not today because we have a full docket today and we can hear that and address the GPS issues.
So we have to miss school today.
Yes.
All right.
All right, who's here on Valerie Garza?
John Young, Your Honor.
Yes, what is happening with Valerie Garza?
State has made an offer.
And where is Valerie Garza?
She is in custody.
All right, come forward, Ms. Garza.
Right now, there's several things on the plate. They have made an offer. We haven't either agreed or denied that at this point. And I'm also asking the court to consider setting a bond. She is remanded without bond on the.
Okay, just 1 moment. Deputy Laura? Brennan, can you let Deputy Laura know that? Go ahead and order lunch for the jurors. Thank you. All right, I'm sorry, Mr. Young. Okay, so what were you saying with Ms. Garza?
On a bond of 20,000 on the cases before the court today. If I had a $10,000 bond, she was remanded without bond because she picked up new offenses. Marcus and I have agreed to recommend the court a $20,000 bond.
All right, Ms. Garza, here's the thing with regards to the new laws that are in place. What I need is I will need more information to see if I can go along with your agreement.
And I will file a motion requesting PR bond.
Oh, just let Ms. Ferguson know that we want to request a PR bond. Ms. Ferguson, a PR bond is going to be requested on Valerie Garza.
Yes.
And just make sure that it's notated, it's for me to consider a bond amount.
I thought I had to file a case for it. I didn't realize.
No, we'll do it. Hopefully it'll go quicker that way. So an offer has been tendered.
It has, Your Honor. That
3 or 4 officers.
All right, state, the offer that's tendered to Ms. Garza, is that a global offer for all of the other unindicted cases as well?
Yes, Your Honor.
All right. And do you have all of the discovery?
Not on the unindicted cases.
All right, state, can you make sure Mr. Young gets all of the discovery on the unindicted cases?
Yes, Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Ms. Garza? Ms. Ferguson, I need a 30-day reset on Ms. Garza. All right, so we're gonna come back on October 25th, and of course, if the application for the PR bond is sooner, we'll come back sooner for that. All right, is there anything else? All right, Deputy Laura, we're done with Ms. Garza. Jorge Terrazas. Oh, are you still conferring?
Judge, I just need a reset on that. There's a lot of discovery I still need to go over. If I could get at least a 30-day reset.
All right, Mr. Terrazas, come up. When were your other cases set, Mr. Hill?
October 7th, that was 2 weeks.
Oh,
I need a little more time on this.
all right, Ms. Ferguson, I need a 30-day reset on Terrazas, please. All right, Mr. Terrazas, you need to make sure that your attorney has all of your contact information, okay? All right, we're gonna see you back on October 25th, okay? You'll get a reset form from Ms. Ferguson.
Thank you.
You're welcome. And Brenna, do you see Terrazas? Thank you. I just scrolled right past him. Who's here on Alberto Trevino? All right, have your client come up. All right, what is happening with this case?
It's still on your trial.
All right. So, Mr. Trevino, as I've been telling you, everyone else, we still have a jury out, so I can't do your jury trial today, okay? All right. And I have a discovery acknowledgement that was done in March. So is there any additional discovery that needs to be filed, discovery acknowledgement?
I don't believe so, Judge.
All right. So Ms. Ferguson, I need a quick jury trial date for Mr. Trevino. State, how long do you anticipate this lasting?
This will be a quick trial. I imagine we can finish our case in chief in a day.
All right. Defense?
How long do you?
Oh, he's anticipating a day, and that doesn't include jury selection. So just approximately how long do you think your case will last?
I'm agreeable to that, but maybe a couple of days, Matt, depending on what we do. I think we've done a election of punishment.
Let me see if I have who would you be going to for punishment if he were found guilty?
I'm thinking about that.
Okay, all right, we'll come to that. All right.
Thank you.
He probably needs to go to the jury, Judge. He's probation eligible only on
Yeah.
behalf of fault from the jury.
All right, so, well, I leave those choices up to counsel and client. So Norma, this trial will probably last, including jury selection, 3 days at the most. All right, so we'll be back on October 25th for your jury trial. And that's when we'll hear it, okay?
Yes, Your Honor. Thank you, sir.
All right, thank you. Just get a reset form from Ms. Ferguson.
Yes, Your Honor. Thank you.
You're welcome.
Yes.
Who's here on Alejandra Alamans?
Your Honor, Edgar.
Thank you. Alamazon, all right.
Yes. Sorry, Judge, I had stepped out to go to another court.
That's okay. Alamazon, where are you? Yes.
Right here, Your Honor.
All right, state, this is a criminal trial division. So last time we were here, there was an issue with the download of discovery. Has that taken place?
Yes, Your Honor, we're taking care of that.
All right, state, were you able to make an offer today?
Yes, Your Honor.
All right, Ms. Ferguson, can I have a regular reset of 30 days on this case, please? I'm sorry, what? All right, so Ms. Almazan, what's going to end up happening is you're going to come back on the 24th. That'll give you time to speak with your attorney. Then when you come back on the 24th, I'm going to give you a plea deadline date, okay?
Yes, sir.
And at that time, the state will need to have filed the acknowledgement of discovery. Is there anything else, defense?
That's all, Your Honor.
All right, thank you. Just get a reset form from Ms. Ferguson.
Thank you.
You're welcome. Who's here on Jorge Terrazas? Are you still? Oh, that's been done.
Yeah, I did.
All right, who's here on Randall Hart? Randall Hart. They're not ready. All right, who's here on Stephen or Stefan Smith? Could parties approach, please? Court is calling 2022 CR 5033, State of Texas versus Stefan Smith. Could I have parties announced for the record for the state,
Catherine Pollard.
for the defense?
Shannon Lock for Stephen Smith.
Okay, is this Stefan or Stefan?
Stefan.
Stefan?
Yes.
All right. People are not spelling names correctly, I think. All right. Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and that you review it with your client?
I haven't, I just.
Court will find that the state is in compliance with discovery. Mr. Smith, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, no, we're waiving counts 2 and 3 on the indictment.
Any objection?
No objection. Your Honor.
All right, next I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit and Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with the assault, family, choking, strangulation as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand? Just one second, I'm sorry. Okay. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 1. They were recommending community supervision. They're taking several cases into consideration. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own, possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
And also the state is requesting restitution in several of the cases that are being taken in consideration. Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense,
Yes, sir.
state? Next, I'm showing you a paragraph entitled Waiver Repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No motion.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Andre Flores, Brian Sickle, and Amanda Brewer, the BIPP course, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in count 1. How do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge, state would offer what's been marked as state's appeal.
Mr. Smith, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Thank you. Now, can you have the defense attorneys and the interpreter and everyone come back, please? All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking that you follow the agreement.
All right, Mr. Smith, what are your issues? Why are you violent with people? And why do you steal?
Situations and,
Now, what does that mean? Everybody's in certain situations.
yes, I had an anger issue and I'm looking to work on that.
Yeah, but I mean, it takes a lot to choke somebody, right?
Yes, it does.
So how are you working on your anger issues?
You're gonna go to classes and just better myself and just work on it, you know.
Okay, so you haven't been working on it.
I have been working on it.
Well, what classes have you attended?
I haven't attended any classes, but I've personally myself, I've been working on it. I just like just walk away, you know. Have no contact, you know, with the persons and just trying to be a better person.
Okay, is there an issue with your jaw?
Yeah. I've
What
got
happened?
abscess.
Oh, okay.
Yeah.
Oh, that can be painful.
Yeah, it is.
Did they, what are they planning on doing to address that issue?
Antibiotics and they're gonna pull it too.
Oh, okay. You know, in the Old West, they would just pull it. So, all right, are you employed?
No, ma'am.
Why not?
I've been on ankle monitor and I haven't been able to leave the house.
Okay. Do you have any children?
Yes.
What are their ages?
12 and 10.
Where are they?
They're in custody with my grandmother in Seguin.
So why are they not in custody with you or the children's mother?
Because I had a previous charge for previous charge of engagement of children for growing
How
marijuana.
so? Growing marijuana?
Yes,
All right. And why are they not in custody with their mother?
she's being no longer fit for to be a parent.
All right. So what drugs were you all using? The mom?
Marijuana.
All right. Anything else?
No, ma'am.
All right. So you chose marijuana over your children?
No, I didn't.
Well, I
of
mean,
course
yeah,
you
you
did.
pretty much did, because I know about Child Protective Services cases because I used to do a lot of Child Protective Services cases. So if you're growing marijuana in your backyard or wherever it may be, or in your greenhouse, and Child Protective Services takes your children, what they do is they say, okay, we're going to take your children, get your life together. And they give you up to a year to get your life together. You have a free baby. Well, I say free babysitter but really taxpayers are paying for it. So you have a year to get your life together and get it so you can be the best parent for your children.
I tried, but my wife, she didn't want to comply, and so that.
Well, no, that's what ends up happening is if your wife doesn't want to comply for you to get your children back, then you have a choice to make. And your choice is either I work my plan, get my children back and leave my wife behind, or either I just take the easy route out for me and not the easy route for the children and say, you know what? I got backup. The grandparents going to take care of the children. I'm just going to do my thing. And it appears to me that that's what you did. And what I can tell you is I'm not going to allow you to have unsupervised contact with any minors, and that includes your own children. Do you understand?
Yes, ma'am.
So where are you living? Who with?
773.
No, who are you living with?
Myself, just by myself.
All right, because I'm not going to allow you to live with your mother or wherever those children are. You understand? All right, this is what the court is going to do. Court is. All right, so here's the question, State. What did you want his punishment to be assessed at? Because it's a probation, regular probation officer. All right, you all want to fill.
Yes, Judge.
I don't know what you all decided. The length of probation you guys are asking for is 5 years probation. So the question is, if his probation were revoked, how much time would you all be asking for the maximum?
5 years, Judge.
Okay. Right. Thank you. All right, so this is what the court is going to do. The court is going to follow your agreement, sentence you to 5 years in prison, suspended and probated for 5 years. Take in consideration County Court Cause number 661474, 661473, CM number 85614, grand jury number 711094. There's to be restitution and the following cause numbers: CM 85614, grand jury number 711094, County Court Cause number 616474, 661473. There's an affirmative finding of family violence. There's to be no contact with Andre Flores, Brian Sickle, Amanda Brewer. There should be BIPs, cats 1 and 2. Here's the thing, cats 1 and 2 is don't steal.
Yes, ma'am.
Don't steal, don't take what doesn't belong to you. You understand? There should be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You are going to take parenting classes, and if you don't do it here, you know what the consequence is going to be? You could go to prison. You understand?
Yes, ma'am.
So there's to be parenting classes. We'll do the triple T. There's to be regular reporting by Zoom or in person. There's to be UA hotline. And whatever medication they give you for the abscess or pain medication, you need to make sure that probation has that.
Okay.
There's going to be field visits 1 time per month. There's to be no unsupervised contact with minors. Defendant is not allowed to live with grandparents or parents. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. State, what do you want to do with regards to his GPS?
Judge, we would ask to leave it as is.
I mean, that wasn't part of the agreement, Your Honor,
All right, what are you requesting?
that you'd be allowed to take the GPS off.
All right, the GPS will remain for 3 months. If there's no issue with the GPS, then you can come back and the court will consider removing it. He will be allowed to work, but you need to provide proof of employment and a work schedule. You understand?
Yes, ma'am.
So, and there'll be a curfew of 10 p.m. And we'll waive GPS fees. And if I didn't say it, there's going to be field visit 1 time per month. Probation, is there anything else he needs?
Clarify, for the cats, did you want them to take the cats?
Yes, because I sort of just gave it to him, right? Yeah. So here's the thing. And I need you to be honest with me because this will determine whether or not you need cats 1 or 2. How often have you been stealing?
Often,
Yes, how often?
when I was doing it daily.
Okay, yeah, he needs cats 1 and 2. Thank you for your honesty. I appreciate it. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Yes. All right. Is the interpreter here?
Yes, sir.
All right.
Yes, Judge, I just dropped off some motions to withdraw on 3 cases. He's been taken into federal custody. They picked up cases. His family's not cooperating with me. They're not paying. I'm not able to do anything. They
Okay.
seem to think there's something I did that has a case.
Oh, no problem. And they haven't been indicted, so I will sign them.
Thank you for letting me slip in.
Oh, no problem.
I've been trying to pop between the 379th and here and the 144.
There you go.
Thank you, Judge.
Sure. And with this is done. And everyone else, your case that wasn't resolved, we'll see you back at 2 because everyone here needs a lunch break. We're going to take the jury's verdict and then we're going to go from there. So we'll see you all back at 2. All right, and we have the interpreter here. Hi. All right, we're going to go back on the record in 2021 CR 7575. We have a new interpreter present. Could you raise your right hand for me, please? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, thank you. Could you state your name for the record?
Arlene Abrams, license number 2081.
All right, and is Mr. PARADA able to hear?
Yes.
All right, thank you. All right, so state in defense, the court has received notice that there is a verdict. Are both parties ready to receive the verdict, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Okay. And is there going to be victim impact?
Yes, Your Honor. Of 1.
Okay. All right, so everyone in the audience, whatever the verdict is, the court is not going to tolerate any outbursts. All right, we're ready.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict on punishment. Is that correct? And is that verdict unanimous? All right, and Deputy Laura, if you could pass it to the court, please. All right, Mr. Parada, if you could please stand. And the verdict form appears to be in proper order. It says, we, the jury, having found that the defendant is guilty of the offense of manslaughter, now return this verdict as to his punishment. We assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 10 years. In addition, we assess no fine. We have not assessed a fine, and we recommend that the term of confinement we have assessed be suspended and the defendant be placed on community supervision, and it's signed by the presiding juror. Does anyone wish to have the jury poll state?
No, Your Honor.
Defense?
No, Your Honor.
All right, everyone, please have a seat. So ladies and gentlemen, and Brenner, we can go off the record. Ladies and gentlemen, based upon the questions that you sent for us, it appears that maybe you had some questions about what would happen with regards to probation. So what's going to happen now is Mr. Parada is, I'm going to ask for a PSI report so I can make appropriate conditions for probation, because I'm the person who would then be setting his conditions for probation. Does everyone understand? All right. Is there anything else from either side? State?
Nothing from the state.
Defense?
No, Your Honor.
All right. So I'm going to have you all retire back to the jury room and I will meet you there shortly. All right, everyone, please rise. All right, everyone may be seated. So with regards to the juror's verdict, I don't know anything about your client other than the testimony that has been in this court. And usually, because this is a serious case, I would like to have a PSI report so the court can determine what would be appropriate conditions for probation for Mr. Parada. And it also goes as far as to the length of time he would be on probation. And so I'll be able to make that determination once I receive more information through a PSI report. Does everyone understand?
Yes, Judge.
All right. So we're going to reset this for a day for me to make the determination on the length of probation. Right. And so even though I have the trial court certification, because formally he hasn't been sentenced and placed on probation, I'm not going to go to the trial court certification with him until I decide the length of probation. Does everyone understand?
Yes, Your Honor.
All right. So Ms. Ferguson, when can we bring him back for sentencing and see if they can expedite the PSI? We don't need a TAP evaluation.
4 weeks.
Thank you.
Right now, it's anywhere from 6 to 8 weeks, so I can try to push it 4 weeks.
I know you can make it happen. All right. So what date? And does anybody anticipate on calling witnesses? And when I say witnesses, I mean witnesses as it relates to the terms and conditions and length of probation.
No, Your Honor.
All right.
Judge, I think we're gonna be in Alabama, on a federal case that we, the week of the 17th of October.
Do you think, or you know you're going to be in Alabama?
I'm pretty certain, and we have a pretrial conference set tomorrow. To confirm that, Judge.
How long are you going to be in Alabama?
Approximately 5 days, Judge. 6 days if you include Sunday.
All right. So when are you leaving for Alabama?
Saturday, Your Honor, should be the,
What date?
which would be the 15th,
The 15th.
October the 15th.
Oh, you're leaving on October 15th?
Yes, Judge. and we won't be back until trial should end by the 21st.
Okay, she's saying October 4th.
Oh, okay, I thought she said. I thought you said 17th.
Oh, you said the 17th? Oh, my gosh.
Judge, not having by October 4th for sure.
And you say you'll be back when?
We should be back on the 21st. Our plane ticket is back on the 21st.
Just one second. Let me see if I can call somebody. Can we go on mute, please? Mr. Parada. The jury has said that they want you to have probation. So these are one of the tests to see if you're going to be a good probationer or not. So your first step is you're leaving this courthouse and you're going to 207 North Kamal to start the process for your PSI report. All right, is there anything else from either side?
Yes.
Your Honor, just victim impact.
That will have to be after the sentencing. I'm sorry. I'm so sorry, but I can't do it before I place him on probation. Otherwise, persons may say, even though it wouldn't be true, that I was biased based upon what I heard beforehand. I'm sorry about that, but I'm trying to get it done as quickly as possible. That's why I wanted to call for October 4th date.
Yes, sir.
All right, so we'll do it on October 4th at 9 a.m. Is that okay with you all for 9 a.m.? All right, and what we'll do is if everybody's here at 9 a.m., I'll take you all up first before I even call docket. All right. All right, everyone, thank you.
Thank you, Judge.
You're welcome. Can you put that in the phone?
May I approve?
Yes. Did I say 2 p.m.?